Good morning, everyone. We have one panel this morning with several matters to call. I am Justice Motuige. To my right is Justice Delaney, and to my left is Justice Gooding. First case we'll call is People versus Brybieska.
Good morning, Your Honors. Nate Crowley appearing for Appellant Jesus Brybieska. May I begin?
Yes, do you wish to reserve any of your 15 minutes?
Oh, I'm sorry, I got ahead of myself. Yes, please, I'll reserve 4 minutes.
Thank you.
And if I could have a warning.
I will do that.
Thank you. May I?
Yes.
May it please the Court, Your Honors, I'll start with discussing the instruction from the Supreme Court in 2024 from People versus Flores, where the Supreme Court dealt with a similar situation to this, and a man was on the street and was approached by officers who found it suspicious that he ducked behind a car, bent over, seemed to be fiddling with his shoes, may have locked his car with the remote key fob, and the Supreme Court held there was not reasonable suspicion there. And it's analogous to the lack of reasonable belief here that Mr. Brybieska was armed and dangerous for a Terry search. What's important about the Flores opinion from the Supreme Court is that a community or group's experience with law enforcement is a significant factor which officers must be mindful of and courts should consider in evaluating objective reasonableness of an asserted suspicion of criminality. And so here, where we have a heavy argument from respondent that it's about the totality and that each of these factors in the totality supports a reasonable belief, here we have every factor colored by Mr. Brybieska as a minority's experience with police impacting the officer's belief. And so when we have issues here like baggy clothing, an assertion that the clothing was dark, which we dispute because it was white and yellow, the assumption that he was in a gang because of the Green Bay Packers hat, football clothing, and the M tattoo. And again, as I assert in the brief, even though the officer knew about Mr. Brybieska from briefing at the police department, there was a lack of information about violence or gangs about Mr. Brybieska. And then we have the hand movement, which we contend the video shows is gesticulating, and a still hand. All of these are colored by what courts should consider as the reasonableness of a belief that there's a gun or a weapon when the court should consider the community's experience with law enforcement. But the biggest one in the context of the Flores the instruction from the Supreme Court in Flores is the officer's heavy reliance on the idea that Mr. Brybieska was being aggressive. And as I emphasize, this is somebody who does not get loud, uses the word sir at least 10 times, says please, uses the word respectfully a few times, and when he's pleading to just be let go and walk home, that is exactly the kind of situation where the Hispanic male's group experience with law enforcement should be considered in assessing the objective reasonableness of the...
I'm sorry, is there a difference, counsel, between aggressive and recalcitrant?
I would say...
And is it fair to characterize him as perhaps the latter, if not the former?
Possibly, yes. There's certainly, because there's the police interaction where the person is very deferential and bowing down, so to speak. And I agree that my client didn't do that. But it's where we have the gray area where they're not bowing down, but also not being aggressive, which I think is where my client lands, that the community's experience with law enforcement as it relates to reasonableness, becomes the most important. And the other important thing to consider here is that the officer describes it as aggression, but he seemed to get a lot of things wrong, like the clothing being dark when it was actually white and a very bright yellow. He also seemed to get it wrong where he said that the hands shot to the cuffs, but we really see that in the exhibits that I put on my brief, that's not exactly what happened. He's gesticulating. And I wonder if that's not because, and with all respect to the officer, this is somebody who's been on the force for 2 years. And I wonder if he doesn't make his own assumptions because of his prejudices as it relates to this community. Because the other thing Flores talks about is how Hispanic individuals are the largest racial group of stopped individuals, and they're also more likely to be searched than stopped white individuals. And so I see the officer's testimony about most of the time when it's me and another person, they're going to get patted down regardless of who they are. It's common practice. And then later he says, as long as they don't have any weapons or drugs, they're most likely to go free with a citation or a warning. And I just really wonder if that's true. If, say we have an Asian American in a Cal State Fullerton jacket on a bicycle, or if we have a white person wearing medical scrubs with a jacket, I can't help but wonder if the same approach would apply based on some of the responses this officer gave. And so, in light of the fact that we have the handful of inconsistencies from this officer, and so what I'm getting at here is that I know that police have a tough job. I know that it's a scary job and a risky job, especially at night. But our position is that the reasonable suspicion to believe that somebody was armed and dangerous needs to be more thoroughly developed to be constitutional here. And one of the things that I talked about in the briefing is the comparison to the Esparza case, where there was essentially an expert, the veteran gang detective, who said that yes, this person's in a gang, he's known to always be strapped, yes, this gang, specific gang, is dangerous, yes, this specific area is a contentious turf war area between two violent gangs. Those are all part of a very developed record in Esparza. Here, we have a thin record in that the officer throws out, he could have been in the Monos gang, but we don't have information about, are Monos members dangerous? Is Mr. Bribiesca specifically a dangerous member? Is this area in front of the police station the subject of some kind of turf war? Have there been prior violent incidents in this area? We don't have any of that. And to me, when I read the record, they almost feel like catchphrases, especially the way he threw in gang area at the very end of the testimony, as if that's a magic word to justify police action after the fact. And so I'd ask you to consider the record here with respect to some of these issues compared to the record in cases like Esparza, where it was well developed, to show the inferences that respondent asks you to take. In order to have those inferences, I think we need to have a well-developed record first to base the inferences on, and that is missing here compared to some of our precedents.
Mr. Crowley?
Yes, sir.
Good morning. How do you factor in, if at all, the relatively recent prior arrests for gun possession?
My position on that is that I think it's Pantoja covers that a prior conviction for weapon possession, let alone a prior arrest, is not alone enough to justify reasonable suspicion. What I would say is the record is not terribly clear on why it was dismissed. It may have been he didn't have the weapon. It may have been it wasn't actually a weapon. It may have been the weapon was lawfully possessed. And in a country where there are Second Amendment protections, people are entitled to possess firearms, albeit with limitations, the fact that somebody on one occasion, on one day, had a gun that was not used for anything violent does not amount to reasonable suspicion that on this day, Mr. Bribiesca was not only armed but also dangerous. Because in a country with Second Amendment protections, people are frequently armed lawfully. And I think it's important that both in the H.H. California case, as it cites the U.S. Supreme Court in Minnesota versus Dickerson, the person has to be both presently armed and dangerous. And this brings me back to Esparza, where they had information about this specific gang being dangerous. But here we have nothing to show that Mr. Bribiesca was specifically dangerous. There's also the Bush case, which is in my briefing, where the dispatcher told the officer that the person had a history of violence. And I think maybe it was an MMA or kickboxer type who had been aggressive with police in the past. Again, these are things that need to be in the record to support that dangerousness finding. And here we don't have it. We have somebody who's mistaken for being aggressive while pleading to be let go. And I make the same comparison. I wonder if there's an Asian American student in a Cal State Fullerton jacket who's saying, "I'm sorry, officer, just let me go home. I'm sorry, I know my rights." I wonder if that person gets frisked.
You've mentioned the clothing a couple of times and put different letters on it and talked about the color. I don't recall you addressing the size of the clothes or what may have been characterized as something like baggy and therefore having room to conceal something.
Yes, sir.
If you mentioned it, I didn't hear it. How does that factor into the totality?
I have a couple comments on the clothing. Number one, it's the Collier case, which is covered in my brief. I know I covered it in the reply. In the Collier case, the clothing is described as extraordinarily baggy. I think the shirt went down to the person's knees, and my client's clothes certainly aren't snug fitting. They're on the larger side, but they're on the bell curve within an average, especially and this brings me back to cultural considerations when we talk about the Flores case and the statistics about non-whites, specifically Hispanics, being the largest proportion of stopped individuals. We have somebody where the cultural customs of dressing in a certain way are used against him to support a pact for weapons. Number one, I think that creates a problem under Flores. But number two, in the Collier case, the opinion was very careful to say, and I think the word they used was carte blanche. Baggy clothing is not carte blanche to do a search. And here, the clothing was nowhere near as baggy as what's described in Collier. And the last thing I'll say is, and this goes back to the underdeveloped record, in Collier, the officer testified, because of the baggy clothing, I thought there was a weapon concealed in there. Here we have, the clothing was baggy. But the officer says things like, I didn't want to risk it, and it's my policy and procedure to search almost everyone. And so there's not that piece of the record where the officer articulates, because of the clothing, I had the belief there was something in there. And so,
Mr. Carley, you're actually over, but we asked questions, so you're at your 4 minutes. You have
Okay.
4 minutes left.
thank you. So I believe that based on Collier and based on the impact of Flores on the clothing issue, that is a thin factor and does not support the totality.
One point of clarification, Mr. Crowley. You said that this officer said he stopped and frisked almost everybody. I think he said it was the custom, either his or in the department, to stop and frisk everybody on a bicycle or something more limited than what you said. I may have that wrong. I'm not sure it's entirely important, but I wanted to clarify.
I agree, and I don't have the quote handy, but
Okay.
in general, I think he's talking about bike stops, yes. I wanted to address the prolonged stop, but I think I will save that for rebuttal if time permits. Thank
All
you.
right, thank you. You'll still have your 4 minutes.
Good morning, Your Honors, and may it please the Court. Deputy Attorney General Emily Reeves on behalf of Respondent, the People. This Court should affirm the decision of the trial court because the officer had reasonable suspicion that appellant was armed and dangerous under the totality of the circumstances, and any delay was reasonable under the circumstances. Starting with the first point, the officer had reasonable suspicion that appellant was armed and dangerous. Officers may conduct a brief pat search if they have reasonable suspicion that an individual is armed and dangerous, and the court looks at the totality of the circumstances. It's important to note that the factors are not viewed in isolation, but altogether. And here, the officer identified several different factors that supported his decision to conduct a pat search. The stop occurred late at night. Appellant was wearing baggy clothing that the officer recognized as being affiliated with the Monos Gray Street gang. The officer was alone and recognized appellant as an individual with a history of carrying an illegal firearm. And so specifically, as it relates to the clothing, the officer recognized appellant's hat, which was a black hat with the letter G for Green Bay Packers. The officer used his training and experience to identify that this could be affiliated with the Gray Street gang. He was also wearing an athletic jacket with the letter M on it, which the officer identified as being affiliated with Monos, and he had the letter M tattooed on his face as well.
So, Ms. Reeves, good morning. There's no indication that I saw on the record that that particular gang had any history of violence or was known for violence. Is that accurate?
That is accurate.
And how does that factor into the totality then?
On the record, you're right, Your Honor, they don't talk about whether or not this gang has a history of violence, and it definitely is a consideration, but the court looks at the totality of the circumstances and the fact that appellant was arrested previously for possessing an illegal firearm.
I understand. That's a separate factor that I understood from both of your arguments so far and from the record. So I'm just addressing the one factor that that plays into the totality, as you concede. So without, I mean, it could be a gang, it could be a bicycle gang, it could be any kind of club without violence. How does it become even a factor for totality in this context?
I apologize, Your Honor, can you clarify just
Sure,
the fact that
without a history of violence or any indication that that particular gang has any violent history at all, how does it become a factor at all that this person might be armed and dangerous?
The officers are allowed to rely on their training and experience, and this officer did have extensive training with the gangs and even identified specific gang areas. And while it would certainly be helpful if the officer identified on the record whether or not this specific gang was known for violence, it doesn't preclude a finding of reasonable suspicion here for the officer. And the standard is reasonable suspicion. The officer didn't need to know with absolute certainty that appellant was going to be a violent individual.
So is your position, if an officer says, I thought he was potentially affiliated with a gang, any gang, that would support reasonable suspicion?
When you say any gang, Your Honor, do you just mean like, oh, I think he's in a gang, or a specific gang in general?
I think he's a gang member.
I think that
And
that
we don't have
would,
any information about the particular gang and its activities, propensity for carrying weapons, propensity for violence, or the point that Justice Delaney has just made. Would it be enough anytime an officer says, yeah, I think he's a gang member? He's got a face tattoo.
I think that that fact alone would be a weak fact, but here the officer did identify a specific gang that appellant may potentially be affiliated with, and that in conjunction with the other factors present supported the officer's reasonable suspicion to conduct the pat search. And the officer even identified this as a known gang area and identified Euclid Street, which was where this stop occurred just after midnight, as being a known gang area as well. And appellant was also behaving in a way that delayed the encounter with the officers. And appellant cites to People versus Flores. And there, the officer relied on the fact that appellant was behaving erratically or evasively with officers, and also that they were in an area that was known for narcotic sales. And based on that, the court there found that there was not enough for reasonable suspicion to find that the appellant or the defendant there was armed and dangerous. But here there are several more factors that are present that justify the officer's decision to conduct the pat search. So
Would you agree, after seeing the video, that Mr. Grubieska wasn't acting aggressively?
he was not acting aggressively, but he was behaving evasively and was delaying the officers in the performance of their duties.
But there was nothing about this particular neighborhood except that it was, according to the officer, a gang area. Is that right?
Yes, Your Honor.
Not high traffic and crime or anything like that. It was just a gang area known to the officer.
Yes, Your Honor.
And you wouldn't agree, Ms. Reeves, that asserting your rights or questioning what an officer wants to do is necessarily aggressive or resulting in delay?
It's not necessarily aggressive, but because this was a lawful traffic stop here and the officer did have reasonable suspicion to support that pat search, although appellant can assert his rights, he ultimately obstructed or delayed or resisted the officer in his ability to conduct that pat search, leading to his arrest for violating Penal Code Section 148. Under the totality of the circumstances, the officer had reasonable suspicion that appellant was armed and dangerous. And finally, any delay here was reasonable under the circumstances. During traffic investigations, officers can attend to the reason for the traffic stop and also may attend to any related safety concerns. And here, the officer determined that he needed to conduct a pat search based on the totality of the circumstances, so he was attending to related safety concerns. Any sort of delay was caused by appellant's own evasive behavior with the officer, and can be seen in the body-worn camera footage. So in the first 3 minutes of the video is where the officer tells appellant he's going to conduct the pat search. And appellant doesn't even identify his name until the first minute and doesn't tell officers until about the 2-minute mark that he doesn't have any identification on him. Around 2.5 minutes, the officer...
Does he need to have identification to ride a bike?
He does not need to have any identification to ride the bike, but if the officer was going to conduct the traffic stop, he needed to be able to confirm appellant's identity to issue any sort of citation here. In around 2.5 minutes is when the officer told appellant that his own evasive behavior was inhibiting his ability to tell him why he even stopped him in the first place. So, any delay here was reasonable under the circumstances. For these reasons, respondent respectfully requests that this court affirm the decision of the trial court and deny appellant's motion to suppress. Unless there are any further questions, respondent submits.
You listed as one of the factors that would lead to a reasonable suspicion that he was armed and dangerous, the fact that the officer was alone. Why does the fact that the officer was alone lead to a conclusion or a suspicion that he was armed and dangerous? I can see where it might make an officer more apprehensive, but I don't see how, and I'd like you to help me understand, the officer being by himself gives you more reason to believe he's armed and dangerous.
It does not give more reason to believe that appellant is armed and dangerous, but it does go into the safety concerns for the officer. And when looking at the totality of the circumstances here, the officer knows appellant has a history of carrying a firearm, identifies his clothing as potentially being affiliated with a gang. It's late at night in a known gang area. So him being alone definitely is a consideration when making that determination as to whether there was any sort of appellant was armed and dangerous. But that alone.
Okay. You have used the phrase several times, a history of illegal gun possession. Is it anything more than the one prior occasion some months prior?
Just the one prior occasion, I believe like 3 months prior to this incident.
Thank you for the clarification.
Thank you, Your Honors.
I'd like to just start where Your Honor left off about the firearm history. I want to push back on respondent's position that the gun that was in the prior incident was illegal. I don't know that that's in the record. I think we have somebody who possessed a gun, a case was dismissed, and that's really all that's in the record.
Does it matter whether it was legal or illegal? Just the fact that he had been known in pretty recent history to be carrying a weapon. Wouldn't that be enough to cause some reasonable concern that he might, on this occasion, be armed and dangerous? Unlike the Pantoja case where the prior incident was years earlier. This is pretty fresh.
I don't, on the one hand, I wonder if maybe somebody who just ran into trouble for having a gun is less likely to have a gun again 3 months later because I don't want to go through that again. Is one side of the coin. On the other side, with something like guns where it's so entwined in culture and identity, I don't know that years ago is less likely to possess a gun now compared to more recently. Maybe with something like drugs where, hey, I used to use illegal drugs 10 years ago, but now it's very unlikely. But if you had illegal drugs 3 months ago, it's probably more likely. I don't know that there's as much attenuation with the time gap there, but I just would fall back on the Second Amendment issue in that there's going to be a lot of people who possess guns legally in this country, and there also is a requirement that the person be dangerous as well. But I do think it makes a difference because when somebody's illegally possessing a gun, that does play into the totality, and I wonder if the record is sufficiently developed there for that to support the totality. With respect to the delay, my counterpart contends that the delay here was reasonable. I would cite to Rodriguez v. United States, the U.S. Supreme Court case, that says that unrelated inquiries should not measurably extend the duration of the stop. And so where we have the officer saying things like, we're not even there yet, let me do my investigation for a bicycle headlight ticket, what is he doing but measurably extending the stop? And so measurable is, as we contend, a low bar. It doesn't have to be significant, doesn't have to be lengthy, it just has to be measurable. And we also have U.S. v. Place, another U.S. Supreme Court case that asks whether police diligently pursue the investigation. And the investigation would be into the bicycle light allegation, not into other things. And so here we have, again, where the officer is saying, we're not even there yet. That makes me think that the investigation is not being diligently pursued. I would also push back on the delay in giving his name, because, number one, the video has Mr. Bribiesca saying his name over and over in the very beginning. And number two, the officer is supposed to already know who he was from the briefing. And so to the idea that this identification issue caused a delay, I don't think holds water, because we have ID already established at the beginning. And so I would also point out that it doesn't seem to make sense that his pleading not to be searched and to be let go could end up being the reason that he gets searched. Like, it becomes a self-fulfilling prophecy there. And the last thing I would point out is that there's a little bit of, again, circular logic or illogical thinking here, where the officer says he needs to conduct a pat search before writing a ticket, but he won't conduct a pat search if he's alone, and yet he's patrolling alone. It's this situation where every single person is set up for the officer to just decide these justifications warrant delays and pat searches. And that's when we run into the statistics that are cited in Flores about minorities facing more frequent stops and, when stopped, more frequent searches.
Mr. Crowley, you're out of time, so if you want to make a closing remark?
Before you do, Mr. Crowley, one point. You mentioned cultural considerations a number of times in the Flores case. Other than what specifically are the cultural considerations here at issue? You mentioned, I think, the clothing, but even if you did, you didn't describe how that was a cultural issue in this context. Can you just confirm for me what you're talking about specifically in this case?
I think that young Hispanic men wearing baggier clothing is a cultural consideration where an officer describes it as unusual clothing, if that answers that question. We have my client who, as I said, pleading, appears to be nervous around the officer. That gets mistaken for aggression, maybe with a Hispanic male, but as I said, with an Asian American or a white person, that mistake may not be made. And we have a few instances of this officer getting things a little bit wrong, calling the clothing dark, saying the hands shot to the cuffs when the video doesn't support it, and again, mistaking this aggression where he says sir so many times and says please and says respectfully, and his voice is more of like a whiny pleading than loud or anything that I would contend is aggressive.
I heard two things then, correct? Two cultural considerations, quote unquote. I just want to make sure I understand your argument.
I have that. I also had it with the assumption that he's in a gang. I wonder if somebody who's not, if it's, to use the example again of an Asian American or a white person, if they're wearing the Green Bay Packers hat, if they're wearing that jacket, if they have a face tattoo, is it assumed that the M stands for Michelle or another thing instead of the Monos gang? And I also would push back on it because, as I mentioned in the brief, there's the G for Gray Street. I think there's the L for Las Lomas. There was another acronym. There was another city that had different letters. And so we get to the point where everything is made to fit this mold. And I think that, again, mistaking him for a gang member with the lack of information to corroborate it would be a third one. And then the other one is, I think, the hand movement is potentially mistaken, where the officer's prejudices as somebody, because I think about lawyers with 2 years of experience, and I think about lawyers with 10 years of experience and how seasoned they might be, or a lawyer with 20 years of experience, and I think the same can apply to an officer.
The hand movement toward the pockets?
The mistaking it.
Has been going toward the pockets. That's a cultural consideration that you want us to make?
I think that the officer's mistaking it plays into the prejudices of an officer with 2 years on the job who's less seasoned compared to a 10 years of experience or 20 years of experience, more seasoned officer.
Thank you.
I have one last question about the clothing.
Yes.
Does it go beyond the fact that it was baggy to include a concern that this was sort of a warm August night and he's wearing kind of a heavy jacket?
As our position on that is that it's nighttime, but cycling is windy. This is not somebody who's exerting himself. We don't see heavy breathing. He's not sweaty. It may be that he's comfortable wearing that jacket while cycling at night. It was a smaller bike, not like a performance bike. I know, just last night, I was wearing a sweater to go out, and it's July. And so I don't know that the summertime means somebody would not be wearing a light jacket. The other thing I would say is if somebody has the jacket with them and they're biking, he doesn't have a bag. Wearing it is kind of the best way to transport the jacket. I suppose he could tie it over his shoulders or something, but it seems like a reasonable way of carrying it. And under the circumstances where he's not sweaty, he's not breathing heavy, it seems like a comfortable way of bringing the jacket along. But I recognize that it's summer. I don't know that aspect is enough to push us into a reasonable belief something is in there, because like the other case I mentioned where the officer specifically testified, I believe there was a firearm under there because it was so baggy. We don't have that here. We have the officer saying, I didn't want to risk it, and this is my policy and practice for bike stops. So I think it's a different situation than some of the baggier clothing precedents.
Thank you.
Thank you.
Thank you.
Thank you to both counsel. The matter is now submitted. Linda Clark versus Iris Smith et al. As both counsel are approaching, I realize that there are two cases that both of you appear on. What I'd like to call first, though, and what we'd like to handle is Linda Clark versus Iris Smith first. Okay? The other matter is Linda Clark versus Precision Air Parts Support Services, so we'll call that second. All right?
Yes, Your Honor.
Is that agreeable to both counsel?
Yes.
Okay, all right.
Good morning, Your Honors. May it please the court. The issues here are
Counsel,
narrow.
can we get your appearance, please?
Pardon me?
Can we get your appearance, please?
Oh, I'm sorry, Your Honor. Patrick Duffy of Montleone and McCrory for plaintiff Linda Clark.
Thank you. And would you like to reserve any of your 15 minutes for reply?
I'll reserve a couple minutes.
Okay. Thank you.
The issues here are narrow, and the resolution clearly should be in favor of the appellant. The promissory notes were clearly community property, and the claim that it was separate property of Donald Sr. is without any supporting evidence. The undisputed evidence is that past was the community property of Don Sr. and Linda Clark. They married out of college, and he started an accounting practice. One of his clients was Pass, which he eventually purchased with community property funds earned in his accounting practice. He had no other source of income. Linda Clark testified to this. It was from community property funds. He had no other source of income.
Counsel, does it matter whether the notes were community or separate once they get put into the trust and become an asset of the trust?
No, it doesn't, Your Honor. In either case, of course, as the trustee or as community property, Linda Clark had standing, and the court in that respect was completely wrong. But the community property is one of the two grounds. That's why I address it.
But even if it were separate property, if it were put into the trust and she's the trustee, doesn't she have the duty and the obligation and the ability to then sue to enforce on the trust asset?
Yes, Your Honor, of course.
Without regard to its characterization.
That's why I say this is so straightforward. In either case, whether it's community property or as a trustee, she had the power and the capacity to bring this case. It's sort of bewildering how the court got sidetracked here. There wasn't any dispute about the trust, and not any dispute about its terms. There was no evidence whatever that she couldn't act as trustee. There was no evidence whatever that it wasn't community property. And there just was no testimony about it at all. But somehow the court came to the conclusion that that she was neither the trustee of the trust or community property. I say without any evidence.
Did the trial court find that she was not the trustee?
Pardon me?
Did the trial court find that she was not, in fact, the trustee? I think that's what I just heard, and perhaps I misheard.
The court found that she had no standing either as community property, which he decided it wasn't, and had no standing to sue as trustee, even though the amendment to conform to proof was allowed. He didn't say why that I can recall. He just ruled that she didn't have standing to be in court. So actually, I mean, it's so simple, Your Honor. Are we also going to address the motion to tax now, or is that?
Well, that's the second issue, is it not?
Yes.
Okay, and I think that's what Justice Motorike has said we're going to call separately.
Right.
We'll address this one first.
All right. Well, Your Honor, I think the matter is clear enough.
All right, thank you. I'll reserve the balance of your time in case you want it for reply.
All right, thank you.
Good morning. May it please the court, Susan Beck for Defendants and respondents precision air part support services, I like to call it PASS because I get tongue-tied every time I try to pronounce it, Ira Smith and Tony Ordaz. I want to address what counsel said about it being so straightforward, because it's really not straightforward. It's the burden on the appellant to show that the judge committed a reversible error, all right? So in the decision, the judge made factual findings. And there was no evidence and there was no legal argument that the notes made it into the trust. Now, what I mean by that is, the trust does say that Mrs. Clark would be the survivor trustee upon the death of Mr. Clark Sr. But the language in the trust, and it says, we transfer all of our property, whether separate, community, as identified in the schedules attached hereto. Well, if you look at the document, there are no schedules attached to the trust. And then it also says, we also transfer all property that we may transfer into the trust by this general transfer. That's not the exact language, and I can read the exact language. By executing this instrument, we transfer, convey, and assign the property described in the attached schedules to our trustee. We also transfer all our right, title, and interest in and to all of our property that may legally be held in trust and that may be transferred to our trust by this assignment. What was never shown is that a general assignment like this actually does transfer something like promissory notes into the trust. And I think that's the key. There's no argument, there's case law that says, when it comes to real property, it's gotta be an actual assignment. And the appellant, argues, well, and the judge relied on the Cucker case, and appellant argues it as well. Judge Larch said, a general assignment may be sufficient to transfer title of personal property to a trust, citing to Cucker. However, Cucker does not stand for the proposition that such a general assignment is sufficient to transfer them into the trust. Now, with all of this said, at the time Mrs. Clark rested, this is the end of her case in chief, she hadn't shown and provided any legal authority that this general assignment would transfer the notes into the trust. And then, after she rested and the parties submitted their written arguments in support and opposition to the 631.8 motion, it became apparent that Mrs. Clark, after her testimony, after she rested her case, rushed off to Colorado and filed these proceedings in Colorado, making the statement that I have learned that I need the pour-over will to transfer these notes into the trust. Now, mind you, and we concede that these documents were not provided as evidence. I can tell you dollars to donuts that if this case had gone forward and my clients had put on their defense, you would have seen these documents. But it was also proper for the judge.
How do we consider documents that you're telling us dollars to donuts are actually out there?
That's where I'm going next. And I completely understand your question. These are records subject to judicial notice. And the appellant says, well, judicial notice was not requested. Well, it doesn't have to be requested. The court can take judicial notice on its own motion. And so these documents were attached, and judicial notice was wholly proper. And even though when public record documents are subject to judicial notice, the truth of the matter set forth in those documents can't be considered. The legal effect can be considered, and the fact that they exist can be considered. And so at the close of evidence, all we have is the general assignment of these notes, and then subject to judicial notice, an indication that after she rested her case, she rushed off to Colorado to get them into the trust. That tells all when it comes to whether or not these documents made it to the trust.
Is it your position that promissory notes may not legally be held in trust?
Absolutely not our position, no.
Okay.
They
Is
can
it-
be,
Okay.
but there were
And is it your
arguments all
position-
along that
Is it your position that they can't be transferred into a trust?
no, it is not our position. But it was argued all along that these are commercial notes, all of the briefing that went back and forth. These were subject to the commercial code, the California Commercial Code, all right?
And why does that matter with regard to whether or not they can legally be held in trust or legally be transferred into trust?
Well, the problem is, I don't have to prove that. It's the appellant who has to prove that by signing a general assignment like this one, it's automatically transferred into the trust. That's the appellant's burden, and there has been absolutely no proof and no legal authority presented on that point. Now, if authority had been presented, then I would look at it and I would try to figure out whether it applied or whether I could distinguish it. But there's no legal authority that I can see anywhere in this case that says a general assignment in this trust document was sufficient to transfer them to the trust. And then we've got the combined problem of California law and Colorado law. The trust document says it's brought under the laws of the state of California and will be administered there. So when you are looking at the judge's decision, he was trying to juggle that as well. You'll see he cited to the Hegseth case. This is what you would do if you're in the state of California. But Colorado revised statute, and he cites that statute, that what you do is you file a petition to have a declaration as to whether or not these are property of the trust. This was never done. There is no evidence in the record of this at all.
Ms. Duffy, I'm sorry, pardon me, Ms. Beck, good morning.
Morning.
I saw on the record that, I think it was Lodge Exhibit 97, that there's actually a list of the assets that were not transferred to the trust. And those included specific life insurance policies, pension plans, retirement plans, commercial annuities, small business stock, and property that by transfer would have certain tax ramifications. One, is that an accurate read of the record? And two, how does that impact the analysis and the argument you're making?
Well, I think what they're specifically saying is, we know these things can't be transferred, so we're not going to transfer them. I mean, life insurance policies are payable on death documents. They are not subject to a trust. Who the beneficiary is who the beneficiary is, whether or not there's a trust. So all of these documents, I took it to read, are understood that you don't transfer them into a trust. But the key language is we transfer all our right, title, and interest in and to all our property that may legally be in trust and that may be transferred to our trust by this assignment.
And you're not contesting that promissory notes cannot be legally held in trust?
I'm not, but I don't see that they were transferred. And she admitted they weren't transferred by filing documents in Colorado subject to proper judicial notice saying they weren't transferred. And I've just found out that I need to use the pour-over will to transfer them in. I think those are her exact words. In the declaration that she filed in support of that petition in Colorado. So from the onset, the first demand on these notes was 8 years and 1 week ago today, in 2017. This has been going on for a long time. And the parties finally get to trial, and she admits in her testimony she never told anybody about the trust. She never provides any indication that anything was done to transfer them to the trust. There's no legal authority under Colorado law or California law that by doing a general assignment like this, they could be transferred to the trust. And then the judicially noticed documents are just an admission. Talk about judicial admissions, but I know judicial admissions apply to the same case.
Let me ask you this. If we were to conclude that these documents were transferred into the trust by virtue of this transfer, would you agree that as the trustee she has every right to sue to enforce them?
Yes,
Okay.
yes. But I think what Judge
And you
Large had
agree
a
that
problem.
Judge Large actually allowed her to amend her complaint to specify that she's acting not just as a beneficiary, but also as the trustee? You agree with that?
Well, yeah, I didn't find an order, and I had to take the record as it was. It is what it is. There's no order actually ordered it filed.
I find two. I find two written orders. A June 12th minute order in which the court reconfirmed its ruling to allow Linda's counsel to file an amended complaint. And then again, on September 25th, another written minute order reiterating that the court allowed her to amend the complaint. It seems like that's,
Thank you. I'm sorry
if it's
if I
even
overlooked
necessary,
those.
assuming it's necessary.
Sure, and I'm sorry if I overlooked those. But I think where we're going with this conversation is whether or not they made it into the trust, and if so, could she sue on them? And I think that was Judge Larsh's problem as well. I think the community property is a red herring. The evidence is, there's substantial evidence for the finding that it was not community property. And I don't think we need to go there. Her husband bought the company from his mother, and the consideration for that purchase was real estate that she gifted to him, which is separate property. He signed everything as the owner of the corporation, as the seller of the stock, as on his own. She never participated in any of that. So I think the community property thing is a red herring, and I don't think we have to go there. I think the big question is whether they made it to the trust, and we would assert that they did not make it to the trust. I know of no authority that allows promissory notes to be assigned to a trust with a general assignment. And Judge Lars.
So when you say general assignment, your position is there would have to be a specific enumeration of the particular promissory notes? Is that what you're drawing a distinction between what you call a general assignment and something else?
Sure. One of the cases that was cited here, and
Well, I'm just asking for your position. You keep saying the problem is this was just a general assignment, and it had to be something else.
Right.
And I'm trying to understand what you're saying is the something else. In your view, does it have to be specifically enumerated? I'm transferring this particular promissory note into a trust?
or execute a separate document attached to the note itself, I would think. The Cooker case that was cited by the judge, the petitioners brought a Hegstead motion. Of course, there was no competing law of another state anywhere, but they brought a Hegstead motion to have the court confirm that stock certificates could be assigned to a trust with a general assignment. And that's where the court said a lot of things may be assigned as a general assignment, and we find that stock certificates can be assigned by way of a general assignment. But that was about stock certificates. And I think what Judge Larsh was looking for was something from California law similar to the Cooker case and Hegstead, or from Colorado. Please, just tell me whether these notes are property of the trust. I need to know this, because all along there's no proof and no case law that assures me that it is. And so I think the appropriate step to take is, in California, either do a Hegstead petition, or in Colorado, do a petition under the Colorado revised statute that he cited. May I proceed? I just want to.
1 minute left.
Thank you. I just want to address the judicial admissions argument. In the opening brief, a number of cases were cited about how judicial admissions in your pleading take the matter out of the burden of proof requirement. They were all MSJ cases, and in our respondent's brief, we argued that they were MSJ cases. But in the reply brief, the appellant cited a case, Valerio versus Andrew Youngquist Construction, And in that case, there was a complaint and a cross-complaint. And in answering a cross-complaint, the plaintiff in the main action admitted that a contract had been formed between the parties. And also in discovery, in response to requests for admissions, he also admitted that a contract had been formed. Well, down the road, when it came to trial, he totally changed his tack, and he prevailed on a finding that no contract had been entered into. And so the question on appeal was, were those judicial admissions? And the Court of Appeals said, well, yes, they were. And by the way, and this is what the court said, although Valerio could have done so, he did not request opportunity to orally amend his answer at the time, nor did he request a continuance to file an amended answer. So all he had to do was withdraw those admissions. I'm guessing it was a verified cross-complaint because you don't admit, you always do general denials if they're not. But all he had to do was withdraw those admissions. Well, in our case, the entire lead case by my clients was withdrawn. It was dismissed. It was completely dismissed. And so under Valerio, they followed the roadmap by that court by withdrawing whatever admissions, and I don't believe there were admissions, but I just want to make sure that it's clear that a dismissed consolidated lead case that is dismissed is the same thing as what happened in Valerio. Does the court have any more questions for me?
I'm not hearing any. Thank you.
Thank you.
Mr. Duff, you have 11 minutes remaining.
I just want to respond to a few of the comments made by counsel. First of all, the statement that the pass was bought from his mother is completely factually incorrect.
And why does it matter?
Pardon me?
Why does it matter?
Well, it doesn't matter, but the fact is that didn't happen. I mean,
Okay.
it was.
Let's talk about things that matter. Would you like to address, I would love for you to address, her comments about the Colorado probate filing and what impact, if any, that has in terms of judicial admissions?
The Colorado probate filing has nothing whatever to do with this case. As a matter of fact, after this case took place, as purely as protection against the possibility that this case has not been, will not be reversed, and the position will somehow be taken that the trust is not enforceable, or that the notes are not in the trust. We filed a Colorado action to confirm that, and we've actually filed another action, which is in effect a standby action on the notes. But they have nothing to do, neither of those had anything to do with the resolution of this case. Obviously, we don't want to have to go and do this all over again. At the time that this motion was granted, this was a court trial, and the evidence came in sort of at the convenience of the witnesses. At the time that we rested, the case was over. The defense had one witness left, an expert whose testimony was such that I read most of the deposition into the record. There was 45 minutes left in this trial when this motion was granted. And so all the evidence is there. This case should be reversed to the trial court upon the evidence it's already received. And if this one witness wants to be called, so be it. But the court just completely could not understand somehow community property rules or trust rules. And
So your position is we should reverse and remand for the final witness or witnesses?
Yes,
for the
Your
trial
Honor.
to continue?
yes,
Okay.
thank you.
Thank you. The matter is submitted. I'll call Linda Clark versus Precision Air Part Support Services. Mr. Duffy?
This is the motion of
This
tax.
this is the motion, yes.
Thank you, Your Honor. The 998 offer did not include acceptance language. And an otherwise clear Section 998 offer is not rendered invalid simply because it does not track previously the language of the statute. This is the position of the defendant relying on the Darden case. But they ignored the fact that this case was specifically superseded, and the statute was actually changed because of it in 2006 when the legislature added the mandatory acceptance language in CCP 998. The offer was also made in the Pass versus Linda Clark case, not the case where Linda Clark sued on the notes, and is meaningless since the Pass versus Linda Clark case was voluntarily dismissed by the plaintiff at trial because it did not prove a case. Moreover, how was Linda Clark, as a defendant in that case, supposed to file a judgment in her favor as a defendant where there's no cross-complaint? It was simply completely in the wrong case, and there's no possibility of acceptance, so how can it possibly be enforceable? The other one I want to address is the request for sanctions. A plaintiff has requested, because the appeal from the cost bill was as to all defendants, when somehow it should have been only as the Pass. How the plaintiffs, how we would have figured that the tax bill was only, the tax motion was only for one of the defendants and not all of them. I don't see how we could have. But in any event, what was done was to say nothing. The sanction motion claims that the other defendants were somehow distressed by the fact that we thought they were beneficiaries of the cost bill. They're parties. I don't see how they couldn't be, but that only Pass was. They were stressed by that. Well, if that was really true, all counsel had to do was send us a letter saying, you appealed as to all defendants, as to all the parties, and we only are claiming it for Pass. Please correct this. That didn't happen.
What did the court's order say?
Pardon?
To whom did the court's order award costs?
I'm sorry, Your Honor.
What did the court's order say? To whom did the court award costs?
Yeah,
Didn't
awards
it, to all
to
three?
defendants. It doesn't name individuals. Sandbagging this to the last minute and then trying to bring this sanction request for this is just outrageous, Your Honors. Thank you.
Thank you. Reply?
As noted in our respondent's brief and the motion, whether or not the 998 offer actually had acceptance language in it was never raised in the trial court, and I could find nowhere in the file documents. There is no court reporter's transcript of the hearing, no settled statement, no agreed statement. Counsel would like to seize on the statement by the judge that, okay, so it didn't track the language of the statute, and suggest that maybe that shows that it was brought up at the hearing on the motion. Well, there are other reasons it could be said it didn't track the language of the statute. As I noted in our brief, the statute that applied was a previous version of the statute, and we had a consolidation order where the judge had said, the plaintiffs, these cases are consolidated for all purpose, plaintiffs shall always refer to this, defendants shall always refer to that. So in the 998 offer, which on its face, without knowledge of the consolidation order, the statement maybe did seem confusing, but the consolidation order was controlling. You know, you had to refer to Pass's plaintiff, because Pass's case was the lead case after the consolidation order, and you have to refer to Mrs. Clark as defendant, because, for that very same reason. So the language in the 998 offer didn't exactly track the statute either. But the language in the minute order that it didn't track the statute doesn't make up for the fact there's absolutely no record that this was brought up in the trial court. I mean, an appeal is brought up to point out that a judge committed reversible error and to have a court of appeal do something about that. Well, how can the judge commit a reversible error when an argument has never been made on the point they're claiming was error? I mean, it just defeats the whole purpose of appeal. I just wanted to address that. And when it comes to the individual defendants, I'll call my clients the individual defendants, Mr. O'Dowd and Mr. Smith. 3.1700 of the Rules of Court is very clear about who can file a cost memo. The judge's decision after trial already decided that all three of my clients were prevailing parties, and most certainly all three of them could have filed a cost memo, but they didn't. Only Pass did. Pass filed the
What
cost
did the
memo.
court's order say, Ms. Beck? To
My-
whom did the court's order award costs? All three?
Actually, I believe the court's order just struck costs. That's my recollection of the order. Now, if it awarded costs to all three, then that doesn't make sense because all three didn't ask for those costs. So,
Well, I might agree with that, but if in fact the trial court's order awarded costs to all three, wouldn't it be fair then to say that Ms. Clark needed to appeal as to all three?
I don't recall that the order awarded costs. The order decided which costs it would not allow. And it specifically identified which costs it would not allow. And so when it comes to these two individuals having to defend an appeal based on an order like that, it's ridiculous. It's, we're talking $10,000 in costs, and, the whole idea that all we had to do is pick up the phone and call counsel. What if counsel said, hey, it's $10,000, we're gonna appeal this? The phone works both ways, but no, a notice of appeal was filed, and we're all defending. So, Your Honor, if I misread another minute order of the court, I apologize profusely, but I don't recall an award. I recall a statement as to which costs would not be allowed. All right. Does the court have any more questions for me?
Not hearing any.
Thank you so much.
Thank you. Mr. Duffy? You get the last word. Would you
Yes.
like to say anything?
Regardless of whatever any order says, the idea that counsel would not point out an error that she thought was made at the time that it was made and wait a year is unconscionable. The cost bill, to the extent it was made by pass only, if you're gonna appeal, you're gonna appeal to make sure you've covered all the defendants. There was no, costs were awarded to all defendants by the court before the cost bill was filed. In the order, costs were awarded to all the defendants. So if only one puts their name on it, Your Honor, it's just ridiculous to think that appealing when, in that situation, from the whole cost bill and as to all the parties is somehow improper.
Thank you. Thank you to both counsel. The matter is submitted. Next matter, Kyer versus HJC Corporation.
Good morning, Your Honors. Alan Kellogg for the appellant plaintiff, Mela Kayar. I'd like to reserve 3 minutes of my time for rebuttal, please.
Certainly.
May it please the court. This case is about accountability. The question is whether a global manufacturer can profit for decades from the sale and marketing of its helmets in California, and yet evade accountability in California court when one of its helmets fails in a California accident, catastrophically injuring a California resident. The answer, under binding precedent and principles of fairness, is a resounding no. For over 38 years, HJC Korea has sold hundreds of thousands of motorcycle helmets to a California distributor, with tens of millions of dollars in revenue flowing back to Korea. HJC Korea's invoices show sales to a California buyer and shipments marked for delivery in Los Angeles, while testimony confirms that payments were made from a California bank directly to HJC Korea. Testimony also confirmed that HJC Korea routinely and directly sent its helmets from the factory to laboratories in California for testing. Furthermore, HJC Korea, through its wholly owned subsidiary, HJC America, extensively marketed to California consumers. As I will explain, these basic, uncontroverted facts give the court the ingredients it needs to find specific personal jurisdiction and proper service. At the outset, I want to be clear about the appellate standard of review here. It's de novo. We do not challenge the trial court's factual findings. We challenge whether the correct legal standard was applied. As the Aquila versus Superior Court case confirms, the question of personal jurisdiction is a pure legal question. It's reviewed de novo, and so this court must independently assess the legal significance of the undisputed facts that were properly before the trial court. In other words, the challenge here is of the trial court's conclusions as to the legal significance of the undisputed facts, making this a de novo review. By way of roadmap, I'm going to address 2 core issues in this case. Number 1, whether HJC Korea is subject to California jurisdiction, personal specific jurisdiction. And number 2, whether service was proper under state law. I'm going to start with personal jurisdiction because if we don't have that, then the surface issue is moot. Specific personal jurisdiction is a 3-part test, requiring contacts showing purposeful availment, claims arising out of or related to those contacts, and the reasonableness and fairness of California exercising jurisdiction. Everyone agrees this is the applicable test, but the trial court misapplied the legal standards in its analysis of the subparts. So I'm going to address those in order. For the first subpart, purposeful availment, the test was aptly summarized in the 2023 Preciado case, which says at page 978, I'll quote, "In a products liability case like this one, the California Supreme Court has held that a non-resident manufacturer purposefully avails itself of the benefits of California when it takes actions designed to consummate a business arrangement in which it will profit financially by selling its products for use in California, and both knows and intends that its products will enter California and be used in the state." Preciado further explains, California courts have consistently concluded that a foreign corporation purposefully avails itself of the benefits of the California form when it knowingly sells and ships its products to California businesses for use in California. Here, the evidence of purposeful availment that was before the trial court is uncontested and overwhelming. For nearly 40 years, HJC Korea has arranged for its helmets to be sold to a California distributor, with California as the intended destination. Invoices show sales to a California buyer. Shipments marked for delivery in Los Angeles as the final destination. And testimony confirms that payments were made directly from a California bank to HJC Korea. Deposition testimony had further established that HJC Korea's helmets were routinely and directly sent from the factory to independent labs in California for testing. This is not passive or incidental. HJC Korea actively engaged California's facilities to test its products. HJC Korea maintains product liability insurance, naming Helmet House its California distributor, and HJC America its wholly owned subsidiary as additional insureds. This is highly significant. The U.S. Supreme Court in Worldwide Volkswagen expressly noted that a manufacturer's ability to anticipate litigation and alleviate the risk by procuring insurance is central to the fairness of exercising jurisdiction. Here, HJC Korea did just that, confirming that it fully expected to answer for its products in California. Through HJC America, its wholly owned California subsidiary, HJC Korea handled customer service, marketing, testing oversight, and negotiated California licensing deals. The subsidiary has no independent income. It's funded entirely by HJC Korea, and it exists solely to serve HJC Korea's business interests, including negotiating licensing with California companies like Marvel and Activision, providing market feedback, and sponsoring events for top California riders. According to deposition testimony, HJC Korea has invested between approximately $24 to $40 million in HJC America. This kind of investment in its California subsidiary, marketing its helmets to California customers, is nothing short of purposeful availment. Contrast this with the trial court's approach and order. The trial court considered only two factors. First, the distribution agreement, and second, the existence of a wholly owned subsidiary. It then quoted case law that was not discussing specific jurisdiction or purposeful availment, and it then concluded that these two factors do not add up to purposeful availment. But the law requires a totality of circumstances analysis. The court failed to grapple with the full record. The direct sales to California, the California-based testing, the California product liability insurance, and the ongoing exclusive business relationship with its wholly owned subsidiary, in which it had invested nearly $40 million. When you add up these facts and look at the business reality as controlling precedent requires, the only fair conclusion is that HJC Korea has purposefully availed itself of the California market for decades. So having covered that first part, a personal jurisdiction test, the purposeful availment, I'm going to now discuss part two of the test, the arising out of or relating to standard. In 2021, the U.S. Supreme Court clarified in Ford v. Montana 8th Judicial District that the arising out of standard does not require strict causation. And even if it did, we have it here. The first amended complaint alleges negligence in helmet testing. And the uncontroverted evidence before the trial court was that HJC helmets sent directly from the factory were routinely tested in California labs. It's hard to imagine a closer connection between the contacts and the claims.
Mr. Kellogg, good morning.
Good morning.
In fairness, they were tested in other places as well, correct?
Yes.
But they were tested in California?
But they were tested in California, routinely.
Go ahead, thank you.
But as the Supreme Court explained in Ford, when a global manufacturer extensively serves a state market and a resident is injured here, that's the paradigm case for specific jurisdiction. Here are the undisputed facts before the trial court, as previously noted, show extensive service of the California market, sometimes through HJC Korea's corporate form, and sometimes through its wholly owned subsidiary, HJC America. But when, against this backdrop, a HJC Korea helmet fails in a California accident, catastrophically injuring a California resident, the arising out of standard is clearly met. Contrasting again the trial court's order, it misapplied pre-Ford precedent and failed to grapple with the full record of undisputed facts before it. This analysis cannot withstand de novo scrutiny. Finally, for the third part of the test, it's both fair and reasonable to require HJC Korea to answer in California court. They've reaped millions in profits here. They've used California's legal system when it suited them, as shown by their own lawsuit filed here, to protect commercial interests. And they've specifically insured themselves for California product liability. California has a compelling interest in protecting its consumers, and HJC Korea can hardly claim surprise at being called to answer here. So now that I've addressed the first issue of specific personal jurisdiction, I'm going to turn to the second issue of service. If there's jurisdiction, the next question is whether service was proper under Corporations Code Section 2110. The trial court's order sets up a straw man, suggesting that our reading would make any business contact sufficient. That's not our argument, and it's not the law under Cosper or Yamaha. Service on a general manager, per the well-settled case law, means service on someone with sufficient quality and scope of relationship, such that the non-resident company is reasonably certain to be notified. Simply put, the trial court here failed to acknowledge the direct evidence of actual notification and constant contact between the wholly owned subsidiary HJC America and its parent company, HJC Korea. And this removes any doubt that the statutory purpose of service was fulfilled. Mr. Hong, as president and sole officer of HJC America, the wholly owned subsidiary, is the paradigm case. Mr. Hong was a self-described liaison between HJC Korea and its California distributor, Helmet House. And he was also a liaison between HJC Korea and the Department of Transportation, certifying the helmets. As such, he testified to constant contact with HJC Korea, discussing substantive business issues all the time. If Mr. Hong doesn't qualify, then foreign manufacturers could always evade California jurisdiction simply by interposing a shell subsidiary. That's precisely what the law and controlling precedent forbids. But even if there was any defect in service, the appropriate remedy here would be to remand for service under the Hague Convention, not dismissal for lack of jurisdiction.
Mr. Kelly, you have your 3 minutes. You're at your 3-minute mark.
Thank you, Your Honor. In sum, the trial court misapplied binding precedent by elevating form over business reality. When you consider the totality, the marketing, testing, insurance, decades of helmets shipped with an intended destination of California, the only fair and lawful conclusion is that HJC Korea is subject to being held accountable in a California court. Thank you.
Thank you.
Good morning, Your Honors. Keith Sacrell, Littleton, Joyce, Ugetta, and Kelly, on behalf of the specially appearing defendant, HJC Corporation, and respondent. I want to start with the service issue because we don't need to reach personal jurisdiction if service was improper. The trial court correctly found that service was improper here. What the plaintiff attempted to do is serve HJC Korea, a foreign company, a signatory to the Hague Convention, which is a treaty that both the United States and the Republic of Korea are signatories to. Plaintiff attempted to evade the Hague Convention by dumping a summons and complaint on Mr. Hong of Hongjing Crown America, the American subsidiary. Counsel said, well, if Mr. Hong can't be properly served on behalf of HJC Corporation. A foreign corporation can always evade service. That simply is untrue. There's the Hague Convention. The Hague Convention is the proper method of serving a foreign company whose country is a signatory to the Hague Convention.
Well, Mr. Supral.
Yes.
Good morning.
Good morning, sir.
Doesn't Corporations Code 2110 also provide an avenue for service of a foreign corporation?
Well, and I want to address that, because Corporations Code 2110 does talk about serving a foreign company's general manager in California, and that's what the plaintiff is relying on, claiming HJC America and/or Mr. Hong is the general manager. But what we argued below, and the trial court didn't really address this in its order, how do you harmonize that section of 2110 with CCP 413.10, which says the service rules are subject to the provisions of the Hague Convention? I don't believe that issue has ever been addressed by the Supreme Court or any appellate court. My position is the Hague Convention as a treaty is the supreme law of the land, and in this context, where you have a foreign company whose country is a signatory to the Hague Convention, that is the exclusive method of service. You cannot serve a general manager in California when the Hague Treaty applies, as it does in this case. So that's something I think is ripe for this court to look at. I don't believe that's ever been addressed in California. But I believe the supremacy clause in this context would require service through the Hague Convention rather than through a purported general manager in California. Putting that issue aside, is Mr. Hong or HJC America the general manager of the parent company? The answer is no, as the trial court found. What is a general manager? A general manager under California law is one whose supervision extends to all of a company's business, all aspects. HJC America, I think the record is pretty clear, is a marketing company. It is not involved in distribution of the helmets that come from Korea. It is not involved in the sale of the helmets that come from Korea. Those helmets are shipped directly to two different companies, not affiliated with HJC Corporation, Helmet House and Solvins. Those are United States distributors of helmets, not just for HJC Korea, but others, okay? HJC America never touches those helmets. It doesn't market, it does market helmets, but it doesn't distribute them, it doesn't sell them. It's not involved in that core function. So it cannot possibly be a general manager if it doesn't distribute or sell the helmets that are at issue in this case.
Well, isn't there authority for the proposition that ample regular contact with a general manager, or whether it's a corporation or an individual, is sufficient to characterize somebody as a general manager for purpose of authorization for service?
Well, I don't think so, Your Honor. I think the argument that I heard was, and there is some language in these cases about, you know, is the foreign company likely to get notified that somebody has delivered a summons and complaint in California. But that's not the test for general manager. Yes, there is that language in some of these cases, but that is not the test. None of those cases say that's the test, whether the foreign company is likely to get notified. I mean, if that were the test, I could be a general manager. I have foreign clients. If somebody dumped a summons and complaint on me, am I going to notify my foreign client, hey, you've been sued?
In
Of
fairness,
course
it's not whether they're going to get notified, it's whether there's ample and consistent contact that one might reasonably infer that they're going to get notified.
Well,
It's a little bit different.
It's not, I mean, I have ample and consistent contact with my foreign clients,
Well,
but.
the day an
but
attorney is responsible for accepting service
I'd
without
be
authority.
committing malpractice if I didn't notify. It doesn't make me a general manager. But the test is not just contact, regular contact, but whether the subsidiary or the individual in California is basically has supervision over all aspects of the foreign company's business in California. So, for example, in Yamaha, we had the American subsidiary. It had it was involved in everything, including distribution and sale. It had an exclusive distribution and sale agreement with its parent. The products came in from Japan to the subsidiary. They were distributed and sold out of the subsidiary. That is a critical difference with this case.
Well, I heard Mr. Kellogg, and I've read the record, and it may not be perfectly analogous, but both HJC America and Mr. Hong are pretty heavily involved with what HJC Korea is doing. Perhaps not on a daily basis, but there's marketing, there's manuals, there's websites, there's the liaison piece that I heard from Mr. Kellogg, helmets and test riders. There seems to be a significant relationship there that would at least show some evidence in support of finding both HJC America and Mr. Hong as managing agents.
I don't dispute that there is contact and perhaps regular contact. But the test is the subsidiary or the individual in California, does he or she or it have supervisory responsibility over all aspects of the company's business?
And what case are you referring to for that language, supervisory responsibility over all aspects?
I am actually referring to California law. Let me find that.
Because I don't think.
So it's Roll v. Texas Co. It's a 1930 case, 107 Calif, 691-703. There's also a more recent case, General Motors Corp. v. Superior Court, 1971, 15 Calif, 3rd, 81 and 86.
Okay, so I was going to say, and I will say, I didn't see that language out of Yamaha or Cosper.
No, they didn't really address that.
Okay.
But these earlier cases talked about what is a general manager of corporation. It's one who has general direction and control of all of the company's aspects of the company's business, as distinguished from one who has management only of a particular branch. He may do everything which the corporation could do in transaction of its business. That's not Mr. Hong. That's not HJC.
Should we have any concern in citing cases far older than the Yamaha and Cosper case more recently?
I don't, because they've never been overruled. That's good law in California. Yamaha and Cosper never actually addressed, precisely what a general manager does. For example, Yamaha, basically the discussion is the subsidiary handles everything in the United States for the parent, including sales, including distribution, including internal testing, including marketing. So in that circumstance, okay, it's the general manager. Now, I question they didn't address the Hague Convention issue, which I talked about earlier. I think that's something that needs to be addressed. But Yamaha, basically, the American company was the face of the parent. They did everything that the parent could do. It was essentially like the parent had a branch office in California that handled everything. That's what the subsidiary in Yamaha did. In Cosper, involved an American corporation, so there's no Hague Convention issue at all in that case. That's an older case, but again, it involves a local representative who's marketing, who's selling, who's distributing, promoting, doing everything. So it's effectively Smith & Wesson has a local office in California that handles the entirety of the company's business. That is not what we have in this case. We have basically a marketing company, never touches the helmets, doesn't distribute them, doesn't sell them. That's not a general manager under the case law. So, I think the trial court got it right on the service issue, and so this court doesn't even need to get into the minimum contacts, personal jurisdiction argument. I think the trial court can be affirmed simply on improper service, which, number one, I would argue, they have to use the Hague Convention. They can still use the Hague Convention. I don't know why other than perhaps to save some money, why they didn't go through that process. But this is a treaty. Republic of Korea and the United States are signatories. You can't end run the Hague Convention by dumping a summons and complaint on somebody in California. I don't think that's proper. And then secondly, even if you could do that, there's no general manager issue here. Mr. Hong, HJC America is not the general manager under the Corporations Code. So I know I'm running out of time. I just want to briefly address personal jurisdiction, which I don't think the court even needs to get to. I didn't hear anything about general jurisdiction in counsel's argument. I don't think there's any bona fide issue that there's general jurisdiction in California for HJC Corporation. So the issue really is specific jurisdiction. And I would just point the court, the first prong, purposeful availment. HJC America sells helmets to 2 distributors in the United States. Yes, one is in California, and the other is in Massachusetts. At that point, it's not involved with the helmets. It's not specifically targeting California with its helmet. It sells to 2 distributors in the United States. It's up to them how to distribute these helmets. And that, under the Asahi decision, even if HJC Corporation assumes some of these helmets are going to end up in California, that's not enough for purposeful availment. So I think the trial court also got it right on specific jurisdiction. Thank you, Your Honors. If you had no questions, I submit.
Not hearing any, thank you.
Thank you.
Thank you, Your Honors. I just want to briefly respond to a couple of points. First is that HJC America does much more than marketing. The uncontroverted record shows that. Mr. Hong was a liaison between HJC Korea and the distributor, the California distributor, Helmet House. So HJC America is very much involved in that process. Also, HJC America maintains a website where it lists out all of the California dealers for California consumers to go find their HJC Korea helmets and buy them. Furthermore, HJC America would answer calls from its La Habra, California office from customers who had problems with their HJC Korea helmets. This is much more than just a mere marketing company. And I think that, when we look at the totality of circumstances and we ask ourselves about purposeful availment, this kind of investment and targeting of California is clearly purposeful availment. I also think that we're overlooking the most recent Supreme Court authority from Ford versus Montana, which talks about when a company extensively serves a state market, there is an injury which occurs in the state from that company's product. That's the paradigm case for specific jurisdiction. And I don't think that there's any contrary to authority out there on that. Then turning to service. So we touched on a number of points, but I just would urge the court to look at the Yamaha case, which deals with the Hague Convention, says that under the current statutory scheme that service is sufficient. It was a Japanese company in Yamaha, and Yamaha America, yes, they did sell, yes, they did market, yes, they did essentially act as the face of Yamaha in California. But here too, HJC America is doing almost the same thing. HJC America is marketing. HJC America is involved in customer service. HJC America is unlike Yamaha. In Yamaha, Yamaha America was not owned by the Japanese company. Here, HJC America is wholly owned by its parent company, HJC Korea. So I think that, yes, while there are a number of factors that can be considered in whether service was proper and appropriate under the case law, and I don't think that there can be any reasonable dispute that Cosper and Yamaha are the controlling cases. There wasn't at the trial court level, and it's really not subject to reasonable dispute here. But in any event, looking at Cosper, it bears noting that this was a sales representative that was found to be the general manager. So in terms of supervisory responsibility, there was really no connection. Cosper didn't even involve an employee of Smith & Wesson. It involved their a sales manager who did not exclusively serve Smith & Wesson. Unlike here, where HJC America solely exists to carry out the business of its parent company, HJC Korea.
Mr. Kellogg, what about Mr. Saprell's assertion that 416.10 is in conflict with the language of 413.10, I believe he said, or the Hague Convention?
And I think that the court in Yamaha dealt with that and interpreted it in a way that allows for service nevertheless. Unless there's any further questions, I submit.
I am not hearing any. Thank you.
Thank
Thank you to both counsel. Matter is submitted. Winthrop versus Damshak et al.
Good morning, Your Honors, and may it please the Court. My name is Jeremy Suter, and I represent defendants and appellants Evan Damashek and Tripharma LLC. If I may, I'd like to reserve 2 minutes for rebuttal.
Certainly.
This is an important case of first impression regarding the intersection of the Mandatory Fee Arbitration Act and the Attachment Law. Specifically, this is an appeal from an order denying appellants' motions to set aside several ex parte, no-notice attachment orders in an attorney's fees dispute with their former counsel, who are the plaintiffs in response in this matter. Appellants respectfully request that this court review de novo and reverse that order for 3 reasons. First, respondents failed to give appellants notice of their right to arbitrate this fee dispute as required by the Mandatory Fee Arbitration Act, or the MFAA, as I will refer to it. Second, respondents' fee contracts are invalid under the rules of professional conduct. And third, the Superior Court failed to consider any of the quantum merit factors required, the Superior Court failed to consider any of the quantum merit factors required by the Supreme Court's decision in Shepard-Mullen versus JF Manufacturing. I will discuss each point in turn. The MFAA requires that an attorney in a fee dispute must give its client written notice of the client's right to seek fee arbitration. If the client elects to pursue fee arbitration, the underlying civil action is then stayed automatically. If the attorney fails to give such notice as required by the MFAA, then it is grounds for the Superior Court to dismiss that civil action. The legislature enacted the MFAA for at least 2 reasons. One is to provide an efficient and inexpensive method to resolve attorney-client fee disputes. And 2, to prevent the need for clients to hire new counsel, because as the legislature has found in enacting the MFAA, many clients simply can't afford to hire a second counsel to engage in litigation with their original counsel. In Wong, this court held that substantial compliance with the notice requirement is necessary.
Isn't the issue here turning on the timing of the notice and when that notice must be given, and whether or not your client kind of beat them to the punch before their deadline to give the notice expired?
It does, Your Honor, and what I'd say are these are 2 ends of the spectrum between Wong and this case. And what Wong held is, in that case, the attorney had given the notice 2 years before the dispute ever arose. In other words, sent its first bill. Included in that first bill is the client's notice of right to fee arbitration. But that notice rendered the client's ability to enact the MFA ineffective. And the reason is because at the time that the attorney in Wong gave the notice, there was no dispute to be had. Once the notice is given, you only have 30 days to seek fee arbitration. And so what this court held in affirming the Superior Court's judgment against the attorney that dismissed the case, the attorney's fee case against the client, was that even though the attorney's service of the notice, providing the notice prior to service of the summons and the action, technically complied with the MFAA, because he did, he gave it prior to, it was 2 years prior to, but it was prior to. The panel found that that technical compliance is insufficient and that substantial notice is required. And in effect, the test is, if the attorney's technical compliance still undermined the client's ability to petition for fee arbitration and stay the underlying action to prevent the claims against him, then they have not complied with then the attorney has not complied with the MFAA. And we would propose that that's exactly what's happened here, just on the other end. Once again, they did not provide, respondents did not provide any MFA notice relying upon the language in the MFA that says you don't have to give it until before or at the time of service of the summons. And they go, aha, we've never served the summons, therefore we can go and get this attachment. But the problem is that by getting the attachment and not giving my client notice, my client did not have the ability to go and request fee arbitration, which would have stayed the case and which would have prevented the attachment in the first place. And so we have a Wong situation. Again, just in Wong, it was too early because there was not yet a dispute. Here, it's too late because we have a dispute, but they had not yet served the summons. And so we would ask that this court essentially extend Wong. You've already clarified one end of the spectrum, and we ask that this court clarify that on the other end of the spectrum, that if the attorney is aware of an actual dispute and is taking actions against the client, such as a writ of attachment, that would impact the client, that the attorney be required to at least give notice at that time. What the Superior Court did instead was relied upon the Loeb case, which is from a different district. It's an inapposite and, frankly, we submit wrongly decided decision. In that case, the dispute between the attorney and the client had already been stayed. There was MFAA notice. The fee petition had already been filed. And then while the case was stayed, the law firm in that case filed a notice motion that requested a writ of attachment. The Superior Court granted the lifting of the stay, heard the motion, and granted the motion. On appeal, the Court of Appeal upheld that, and in that decision, essentially held that in that case that was proper. The reasons we submit that the Loeb case is improperly decided is because it didn't address at all any notice requirements under the MFAA. It doesn't address at all the purpose or policy of the MFAA. And it doesn't address at all how attachment could possibly be consistent with the purpose and policy of the MFAA. As courts have recognized, attachment is a harsh remedy that causes the defendant to lose control of their property. Attachment is not authorized by the MFAA. And the lone case that the Loeb decision cited was from Massachusetts, and it had absolutely nothing to do with the MFAA. And the problem is that if you enable attorneys to go in and get writs of attachment, and we would submit this case is just limited to this specific set of facts. In other words, it's a no-notice attachment. It prevents the efficient resolution of the case, because now you've got clients who essentially have, as we put in our brief, a foot on their neck, because they are now facing a writ of attachment, which is a big deal because, as in this case, it was a $1.5 million attachment per client. And so that's a very substantial figure and a very substantial pressure point that the attorney has on the client. And for many clients, unfortunately my client had the resources to fight this, but I strongly suspect that many clients do not have the resources to fight this. And indeed, one of the purpose and policies of it is to enable clients who don't have the resources to fight their former attorney to have this quick, efficient resolution. And it undermines that quick, efficient resolution if an attorney can simply go in and get an ex parte no-notice attachment and use that against their client to try and pressure into a settlement.
Well, Mr. Souter.
Yes, Your Honor.
Good morning.
Good morning.
One of the things the Loeb case said was that it pointed out, I should say, that there's no law prohibiting an attorney from seeking attachment orders as a provisional remedy before or during an arbitration under the MFAA. You agree with that?
I agree with that. The MFA says nothing about it. And I would submit that the reason it says nothing about it is because it is absolutely contrary to the purpose and policy of the MFA. There is nothing in the MFA that allows an attorney to go and do that. And so I take the absence of it as support for the fact that they cannot do it, not as some sort of argument in favor of it.
Okay, so the fact that there's nothing prohibiting it.
Yeah, yes, I would.
Misunderstood what you said.
Sure. My position is that the absence of any permission for engaging in a writ of attachment supports the position that an attorney should not be going to do that. And the reason is because as soon as you get that attachment, it's this, what I will call it is extrajudicial in the sense that you're supposed to have the fee arbitration, the client can go in, present the client's case, the fee arbitrators will decide it, issue a decision, and that often leads to a resolution. If I might offer as a personal anecdote, I myself am a fee arbitrator here for the Orange County Bar Association. Most clients are unrepresented. Most clients are very interested in a resolution, and I believe, I don't have figures on it, but I believe that our decisions do lead to that resolution and accomplishes the goal of the act. If attorneys are enabled to go in on their own, because they're attorneys and they know how to do it and they can do it themselves, and they can put that kind of pressure on a client where they have now attached that client's assets and the client has no ability to fight it because they can't even afford an attorney for the fee arbitration, let alone to go into court. They'd have to hire an attorney to go into court to set aside that attachment. That completely undermines the purpose and policy of the MFAA.
The attachment here was truly ex parte, right? No notice.
Yes, correct. There was no notice.
You agree with me that that's not the norm?
I agree that's not the norm. My fear is that if the court were to affirm this decision, it might become the norm. In other words, it may incentivize attorneys to go in, seek ex parte attachments against their client and put pressure on them to try and settle. And so we would encourage the court as a policy.
Perhaps it might make attorneys want to do it more often, but in my experience, trial courts do not lightly grant a writ of attachment of any size, totally ex parte. There must be some pretty compelling reason for it to do so. You're sort of positing that if we were to say this was okay, that it's the end of the world as we know it, because everybody's now going to go in and get truly ex parte writs of attachment. And it just doesn't seem to me that that's a very likely scenario.
It's a little bit of, sort of reading the crystal ball, but I wouldn't want to provide a situation that encourages it. I also think here the problem is, frankly, the respondents went into court. They had an extensive declaration that was submitted by respondent describing in detail all of the perceived flaws of Mr. Damashek and all of the supposed wrongdoings that he had engaged in. Now, we submitted that should not have been disclosed in the first place. That was a violation of the attorney-client duty of confidentiality. But the risk is
that issue isn't before us.
It's not before us.
Okay.
Yeah, I want to be clear, I'm not arguing that issue. But,
Okay.
but the risk is that you could have an attorney who goes in and does exactly what happened here, which is goes in ex parte, doesn't give any notice to the client, essentially poisons the well with the court, and even to the extent that even when the client finally finds out about the attachment, hires counsel, goes into court, and seeks a set-aside, that the well has been sufficiently poisoned that the court declines to set that aside. And so I think that in any instance where there is a grant of an attachment against a client in violation of the MFA, where no notice has been given in violation of the MFAA, that should be reversed. And even if it's not going to lead to a waterfall of occasions, I think even one is in violation of the act and should be reversed.
You are at your 2-minute mark.
Oh, then I will save the remainder for rebuttal.
Thank you.
Thank you, Your Honors.
Good morning, Your Honors. Reed Winthrop on behalf of Winthrop Law Group PC, on behalf of Winthrop Law Group PC and Reed Winthrop. May it please the Court. In a lot of what was just expressed by counsel, actually all of it, I believe, was briefed very well by both sides. And I really don't want to spend a whole lot of time wasting the panel's time rehashing a lot of this stuff. This was a collection case. There were procedures that were taken. The court first reviewed those procedures on an ex parte basis. As the panel noted, they were extreme. It's got to be extreme circumstances. It was granted. It was challenged on a motion. That's why we're here. The motion was fully briefed. There was disputed facts, and the court denied the motion and refused to set aside. The standard review, I think, is clear in the brief on these issues. They are substantial evidence. The evidence is in the briefs. It's in the record. And I believe the court weighed the evidence, and I've asked you to do the same. I would submit on that, unless you have any questions for me.
I'm not hearing any. Thank you.
Thank you.
May it please the Court, I'll just briefly address the two other issues that I had in the beginning, which is setting aside the MFAA issue, the fee contracts themselves were invalid under the rules of professional conduct because the conflict waivers at issue in this case did not provide any actual disclosure of the actual conflicts that were disclosed in the attachment papers by respondents. And what I mean by that is respondents had disclosed that Mr. Damashek had used Tri-Pharma as a personal piggy bank, was using the company to pay off personal debts and personal expenses, and also that Mr. Damashek's criminal indictment had substantially harmed the company to the tune of millions of dollars, both in terms of lost recovery in a bankruptcy case and also led to a claim by the bankruptcy trustee against the company. None of that was disclosed in any of the fee contracts or the separate 2019 conflict waiver. I know that the respondents have made an argument that this is a substantial evidence case, but it isn't, because the only thing at issue are the 3 conflict waivers. That is not in dispute. The court only considered the one separate waiver. But if you look at all 3, there was nothing in there about actual conflicts. And in fact, 2 of them deny there any actual conflicts. The third point was that if the Superior Court in the alternatives held, even if there were not valid fee contracts, that it was entitled, that the respondents were entitled to attachment under quantum Merowith theory. We are not disputing the court's math. In other words, the court's decision whether to include or subtract certain payments that were or were not made. What we're saying is that the court simply applied the wrong factors, did the wrong formula, did not consider at all the factors in the Shepard-Mullen case that are required for quantum merit recovery, and also improperly equated the contract fee with the quantum Merowith fee, came at the exact same number under both theories, and the court in Shepard-Mullen said that was improper. And unless the panel has any further questions, I would submit.
Not hearing any? Thank you. Thank you to both counsel. Matter is submitted.
Thank you,
We
Your
are
Honor.
in recess until this afternoon.
All rise. Thank you. Thank you.
sorry, we just want to make sure we have you and your advocate. Oh, you're the advocate, okay, thank you so much. So, hooked up as what? Just a laptop for her. We can probably get like a microphone, because you guys didn't even give us any heads up, so we don't do stuff like the last. I know, but it was this warning.
Well,
And
she didn't know about it, so Adair called it, so we're.
Here, I have my own plug.
No, we just, it's just a plug until, we don't think there's one. If not, we can plug in.
Okay.
Would it?
Well, yeah, she can just plug it in, and you wanna do that now?
Yeah, can we just set up it, right?
You guys are,
Last.
you're not the first case, but you can put the plug.
We'll just wait, so we don't disrupt anything.
Okay.
Thank you so much.
No worries.
Does that require electricity?
Yeah, the last two cases,
Okay.
so I don't know if you wanna hang around after
I
the
will.
search is soon.
So,
So they just wanna use the connection so she can read from her laptop, and she has like, she has ADA.
just power.
Yeah, just power.
Yeah, we got that power there. I'll
But
set
she's
it
gonna
up.
have to be at the podium so that we can get her recorded. If not, then we need that wireless microphone, like Rory was saying.
So is it two people need power or just one?
Just one.
Okay. I can set up a plug right now.
Okay.
I'll do that underneath you, just go get it now.
Well, they have their own power, they have their own power pack. They have their own power pack.
A power pack.
Yeah.
Oh, wow. So they don't need electricity?
No, I don't think so, because under the podium, there's already a cable,
Okay.
cable thing there.
Perfect.
So
Okay.
they can just put it in there.
Okay.
And that's it.
All right. I'll do that. Thanks.
All right, thank you.
housekeeping items before we get started. If anyone needs to use the restroom, feel free to get up and walk out. The restrooms are to the right side when you walked in instead of coming to the left. While court is in session, we please ask that you do not consume any food or drinks, no gum or candy. Please don't read any newspapers or any books of any sort. Please don't fall asleep. Please don't, no, it's after lunch. No talking to your neighbors, please. If you have a laptop, please make sure your laptop is on silent so it doesn't make any noise. Only counsel and co-counsel are allowed up here at counsel table. There's water up here while you're arguing if you need any water. This podium does move up and down. There's a small black button here, and it'll go up and down for you. Here's the microphone. Please speak directly into the microphone so the justices can hear you, and just be mindful that everything is being recorded. Does anybody have any questions? We should be getting started in just a couple minutes.
grasshopper.
Don't kill it, don't kill it.
Yeah, well.
You should have told us.
He's still alive.
All rise. Court of Appeal, Fourth Appellate District, Division 3 is now in session.
Good afternoon, everyone. I am Justice Moore. To my right is Justice Motoike, and to my left is Justice Delaney. This afternoon, we have 4 matters on calendar, and this panel will preside over all 4. The first case is in re the marriage of Win, Con Quang Win and Win Chow Win.
Good afternoon, Your Honors.
Good afternoon. Just one moment, please. Respondent, I want to just make sure you're on the telephone. Would you give your appearance, please?
Yes, good afternoon, Your Honor. This is Janice Mazer for the respondent.
Thank you, Ms. Mazer. Appellant may proceed and give us your appearance, please.
Absolutely. May it please the court. Arthur Travieso appearing on behalf of the appellant Can Nguyen.
You may proceed.
Thank you. May it please the court. Your Honors, we're here on an appeal from an order that in part set aside a judgment that was entered via a stipulation arising out of a marital settlement agreement between 2 self-represented litigants. Mr. Nguyen, who is my client and was my client at the trial level. I was also the trial attorney on this matter. And the reason why we're here is because we believe the trial court erred in partially setting aside that judgment on several grounds. One of the concerns that was raised in the respondent's brief concerned the timeliness of this appeal and whether or not, in fact, it was an appropriate appeal. Since that was raised in their opposition, and although I think we addressed it, I did want to briefly address one other issue that this court had brought to the party's attention concerning whether this is, in fact, an appealable order. It is an appealable order, we contend, and we believe the court should agree, under California Code of Civil Procedure, Section 904.1, Subpart A2. Specifically, that this is an appeal taken from a post-judgment order that modifies the judgment of dissolution, and specifically that it carved out a portion of that judgment that concerned the division of retirement accounts between the parties. This is a classic appealable order under that section, which specifically says an appeal may be taken from an order, this is a quote, from an order made after a judgment made appealable by paragraph 1, which this exactly was. This judgment of dissolution that incorporated the marital settlement agreement was entered on June 24th, 2020. The order granting respondents' post-judgment motion to amend was filed October 26th, 2023. The appellant,
Mr. Travieso, good afternoon.
Good afternoon.
It is a post-judgment order, but it doesn't resolve all the issues of respondents' entitlement to a portion of the disputed retirement account. So there's more work to be done, though, isn't there?
There is, in the sense that if the court were to uphold the His Honor Judge McConville's ruling, the court would then essentially, that portion of the case that had been fully decided, because the judgment fully resolved all issues between the party. Now there is, at this point, if this appeal does not lead to a reversal and a remand, then we will find ourselves having to litigate the issue of something that had been settled by the parties.
So it's not a final determination then?
It's not a final determination on that issue, but it's the reversal of what was a final determination on the issue. We believe that because that reversal was inappropriate, that what this court should do is reinstate the judgment as it was, which again restores its finality as to all other issues. I should mention that the underlying motion that was brought actually asserted two different reasons why it wanted to set aside the judgment. The court, Judge McConville, actually ruled in our favor on the first, saying that request was untimely. But in this instance, the timeliness issue of the appeal, which is actually something that was raised as well in the opposition, and is in our brief that we demonstrated it was timely, was the fact that, or I should say that the underlying motion itself was untimely, was the fact that the underlying trial court indicated that there had been that this motion had been timely filed because of an allegation that she, based on her statement that she had forgotten about an asset that she had previously had disclosed to her, not only the existence of the asset, but the exact account number, the exact amount that was in it, and even had the username and login information up until the day in which this judgment became a final judgment to have checked the balance. And we're not dealing with two litigants, one of whom was at some sort of either academic or from an understanding standpoint, cultural understanding standpoint, a disadvantage. Both of these people were college-educated folks. This is all in the record. Both of them were college-educated folks, college-educated in the United States. Both had functional knowledge of English, more than functional knowledge. They were fully fluent in English. My client is an engineer. The respondent is an accountant. These were not folks where one side took advantage of another's ignorance or lack of understanding. Rather, this was something where there was actual complete disclosure. And that's the key thing, I think, in our appeal, is that we elicited at trial. Ms. Nguyen, the respondent, specifically indicated she had actual knowledge of these accounts. She had actual knowledge of the account numbers, where the account was held, admitted to having the username and login information, including a password that was current, to be able to access this information at any time. She chose not to.
Well, wait a minute, Mr. Travieso, correct me if I'm wrong on the record. And you just said that she didn't recall the time of trial or at the relevant times, given the statute of limitations, or the time within to file the motion, that she didn't recall that information that you just mentioned. So, and the court found that to be credible testimony.
The court did find
she didn't know. She didn't have actual knowledge. She didn't actually discover it. Correct?
Yeah, that is true, Your Honor. However, I think that what the court failed to acknowledge was that there is the language in the statute that concerns the timing is the timing which the person knew or should have known.
Okay, so the should have known constructive standard is something different.
Exactly.
Okay.
And that is exactly what we are relying on in this appeal, is that with a person who had historical knowledge going back at least as far as 2014, had unfettered access to these accounts, and could have gotten the day she was looking at the marital settlement agreement to sign, could have pulled up her laptop computer, entered in the login information, and gotten account balances, and simply chose not to. Her testimony was, I'd forgotten about those accounts. What's interesting about that is the marital settlement agreement itself references those accounts. That's one of the problems with the should have known issue, is when it's notified in the marital settlement agreement that these accounts are there. The parties are literally dividing up the retirement accounts, and the aerospace accounts that my client, the engineer, had were specifically mentioned there, as was hers. A decision was made, and the parties' positions at the time in which this marital settlement agreement and stipulated judgment was presented was that the parties are making a decision to settle their claims by virtue of her keeping her retirement, him keeping his retirement plans. He had, I believe, two. She had the singular.
Well, beyond the marital settlement agreement, was there any documents or any information that your client had provided the respondent that were maintained in her files, things she could access?
Yes. Well, as I indicated before, she had unfettered online access for the entirety of the marriage, for as long as these accounts existed and were accessible remotely. Additionally, in the record, it indicates both in testimony from Mr. Wynn as well as admitted to by Ms. Wynn that in 2014 there had been a discussion of the aerospace accounts that included, and this was in writing, the account numbers and the amounts that were in those accounts at that time. And she testified, and my recollection is that she testified on the record that she recognized that at that time that he had more in his accounts than she did in her accounts. So the very issue that ultimately needs to be determined is whether or not this is a fair and equitable distribution and whether or not the parties are making an informed decision. She knew in 2014, because she had had periods of not being employed and therefore had less in her retirement accounts, she knew very well, with him having not had such periods of unemployment, that he had more in his accounts. And again, to the day in which that judgment was entered, she retained the ability to be able to access the current balances on those accounts, on each of those accounts, having had access and never having it hidden. The singular omission here was on the schedule of assets and debts. Those specific accounts went inadvertently omitted, and that's the only place where they are omitted, because they're in the marital settlement agreement, they're in prior communications, both verbal and written, between the parties, and they are, in addition to that, and that was made part of the judgment. And our position is, under the should-have-known analysis, that with that body of access, that she had the absolute ability, if she had any concern as to whether this would be a fair and equitable distribution, for her to have simply logged on and she could have found out. And at that point, she could have made a decision, I don't care, even if it does have more. It's very obvious these parties, when they settled their claims, opted to go the route of a peaceful resolution. And even if that meant that it wasn't a perfectly equitable distribution. At this point in time, there hasn't even been an adjudication as to exactly what the disparity is. That's the other problem. That's another problem that exists with respect to with the court's ruling, underlying ruling in this case. Unfortunately, is that the court didn't make the extra step. I indicated in page 20 of our appellate brief the issue that the equitable division of the community property value of these accounts even was warranted without having engaged in any analysis of the value of the accounts. And considering the reasons the accounts were agreed to, or otherwise considering any other accounts that were given to Ms. Wynn after entry of the dissolution of the judgment in June 2020. There was a cash payment made to Ms. Wynn as part of this global settlement agreement. And so without an analysis of these parties' community assets in the collective, using the marital balance sheet to determine whether or not the net distribution is a fair distribution, we believe the court made an arbitrary decision in determining that an asset was unfairly divided without actually ascertaining those dollar values. At the end of the day, what we feel has occurred here, and I do wish to reserve, if I have a minute or two left of time for response to the respondent's argument.
You have 4 minutes remaining.
4 minutes. Thank you very much, Your Honors. I appreciate it. At the end of the day, this is about two parties, two educated, well-informed parties with unfettered access to the assets of the other. There's no assertion here of an actual hidden asset that was truly unknown to anybody. These parties making an informed decision to self-represent, to negotiate a resolution of their divorce, to present that in writing to the court, and the court approving that settlement as a fair and equitable distribution. As those of you who may have served on the family law bench know, even when the parties make a deal, the court retains the power to say, no, this is unfair. This is too slanted in favor of one side or another, and I'm not going to agree to enter this judgment. It's a backstop, if you will, that the family courts have to ensure that equity is done, as these are courts of equity. Ultimately, what happened here was these parties, these informed parties, made a decision not to involve attorneys, not to litigate. The very thing that the family courts constantly recommend and encourage litigants to do. And they made an informed decision to enter a marital settlement agreement that became a judgment, and that judgment was approved by a judicial officer as being fair and equitable and evenly distributed. Then, over 2 years later, and after buyer's remorse hits in, this person comes in, the respondent comes in and wants to reopen these things because she's now having second thoughts. And this isn't something that happened a month after or 6 months after, or even the timeliness of it being a year after under the family code. It's over 2 years after. And as I said, the court correctly noted that in the first instance, it was untimely. In the second instance, the court determined it timely only because of the inadvertent omission of these assets in the schedule of assets and debts.
2 minutes.
Thank you very much. But for that, this court would have also found the second ground for setting aside this judgment, or setting aside this portion of the judgment, as also untimely. The court essentially gave her a do-over by virtue of making that finding. The problem is the court ignored the evidence on the record, the acknowledgments, the admissions made by the respondent of her actual knowledge of these assets. And therefore, there being no concealment, there being no fraud, therefore there being no basis for relief. I will reserve my final time and appreciate the court's time and attention.
Thank you, sir. Respondent?
Yes, good afternoon, Your Honors. Janice Mazer for the respondent. It's our position, as the court knows, that this appeal is untimely and should be dismissed on those grounds. I won't reiterate, unless the court wants me to, all the complex procedural history, but we do believe that it's untimely and should be dismissed. If the court finds that it's not untimely, then I do agree with counsel that the order that has been appealed is appealable. And I think that is because it, unlike the marriage of Loftus, which I think deals with a bifurcated and interlocutory order, which requires a certificate of probable cause to be appealed, this was a post-judgment ruling. The judgment was final, it was entered, and it resolved all of the issues. Nothing was reserved, nothing was bifurcated. So this was a post-judgment order that I believe is appealable. And I also apologize to the court. I found a typo in my supplemental letter brief. I referred to California Rules of Court 8.392 instead of 5.392, which has to do with the interlocutory appeals. So I just wanted to correct that. In the event the court finds that it's not an appealable order, the court inquired whether it should be treated as a petition for writ of mandate, and our position is yes, it should. I think that all of the briefs and the record include all of the elements necessary to proceed as a writ of mandate. The parties and the courts have clearly invested a lot of significant time and resources in briefing this and presenting the case. And I think that consideration on the merits at this point in time is the just result. As we know, the original order setting aside this judgment or modifying the judgment was back in September of 2022, which was nearly 3 years ago. And the court also found that the respondent had presented credible evidence that she'd been defrauded by the husband out of her share of the family home. Well, this was ruled not timely, and so she did not get any relief of that. The reality is, and the court found that really these were the two major assets of the parties, the family home and the retirement accounts. And so for this whole 3 years that this thing has been dragging on, husband has obtained and enjoyed the use of nearly all of the family assets, while the wife has struggled to maintain this litigation and manage her expenses. So for that reason, I think it's just that the court consider this on the merits one way or the other. So I'd like to just address the questions that the court asked in its focus letter. And the first was, should the respondent have known as a matter of law about the aerospace accounts at the time of the disclosure? Our position is no. Knowing something at one point in time does not establish knowledge as a matter of law years later. I think people reasonably and ordinarily just forget things. The question for the court, I think, is not whether she should have been held to have known about the aerospace accounts in 2020. It's whether she should have discovered, whether she discovered or should have discovered the non-disclosure earlier. And that question, the question of when someone discovers something or when someone should have discovered something, has long been held to be a question of fact and not law. There's a lot of cases cited in my brief holding that whether a party has notice of circumstances sufficient to put put the person on notice of a particular fact are questions of law, are questions of fact to be determined by the jury of the trial court. So in this case, whether the respondent discovered or should have discovered the failure to comply with the disclosure requirement, and when that should have happened is a fact question, not a legal one. And this court, I believe, is bound to affirm the trial court's findings as long as there's substantial evidence to support it.
So, Ms. Mazur, this is Justice Delaney. Good afternoon.
Good afternoon.
My read of the record shows that there were documents, emails, information that your client had, the respondent had in her possession since 2014, all of which, or information which related to the 2 retirement accounts. Is that an accurate read of the record?
Yes, Your Honor.
How can we avoid the conclusion that through reasonable diligence, respondent should not have discovered that information within time to file this motion?
Yeah, that's a great question, Your Honor, and I'm happy to answer that. First, I think it's important to note that the statute does not include a requirement for due diligence. In other words, the statute doesn't have place an affirmative duty on the response who receives a disclosure statement to say, hey, I better go through all my records and make sure he didn't leave anything out.
Is that not the definition of constructive knowledge, should have known? Do we not? Does not the law require due diligence?
I don't think that's exactly the same. I think that the difference is that due diligence is an affirmative duty and should have known is a question of what a reasonable person would have known or how they would have reacted to something. And I think that's a fact question. But even assuming, that there's some kind of a diligence inquiry, which I don't believe that there is, the undisputed evidence at trial was that the parties had been married for 22 years. And during all that time, the husband, Khan, had handled all of the family's financial matters and paperwork. And his wife trusted him to do that. Even though they were going through a divorce that was relatively amicable, and she trusted him and she testified to that. Now, it is in the record that 6 years prior to the disclosure, in 2014, Khan had emailed his wife a list of their accounts with their passwords and so forth. But his testimony, his own testimony, was that this was merely a precaution in case something happened to him. This was so that she would have access in an emergency. If he died, she would be able to know what the passwords to the family's accounts were. He testified that he had never seen her log on to that account, and there was no evidence in the record that she ever looked at these accounts at all. She knew at that time, that way back when, that there were retirement accounts with aerospace. But I don't think, given those circumstances, that it's unreasonable for her to fail to recall 6 years later in 2020 that there were retirement accounts through the husband's former employer. I think there's a little bit of out of sight, out of mind going on here. That if this was his current employer, she would know that there was retirement accounts pending.
Well, doesn't the out of sight, out of mind go to her actual discovery as opposed to what perhaps she should have discovered or should have known?
Well, again, I think that the fact that she did not recall that there were accounts from a former employer is perfectly reasonable, particularly since he was the one who handled all the paperwork and handled all the finances. She was not handling these things on a daily basis. So we're talking about 6 years later. 6 years later, should she have remembered that he one time emailed her, account information? I certainly wouldn't. Whether somebody else would, I don't know. But I mean, I think that all goes to the question of reasonableness and whether she should have or not, which is a fact finding. The judge found it completely credible, her testimony, that she didn't recall that. And the other thing that's important to note, and here's where I really digress with counsel, he says that the marital settle agreement specifically mentioned the retirement accounts and that should have put her on notice. Well, they didn't mention the retirement accounts by name. They mentioned retirement accounts. And at that time, she was absolutely aware that they both had retirement accounts from Vanguard. And she knew that that his account was worth more than hers because she hadn't worked, consistently. So the reference to the marriage, she testified that the reference in the marital settlement agreements to them each just keeping their own retirement accounts, she believed referred to the Vanguard accounts. She knew they were unequal, and she was okay with that because her husband had promised to support their daughter who was going through college. And so since he had made that commitment to her, she said, okay, you keep your bigger retirement account. But her testimony was very specifically, but this was as to the Vanguard accounts. What she did not recall accounts from a previous employer. She also, as far as discovery, the argument that there was a legal issue with respect to discovering that he hadn't put down the retirement accounts when she knew there were some retirement accounts. She did not believe that he had to specify all of the retirement accounts in the disclosure statement because the marital settlement agreement agreed that they would just each keep their own. Again, with her understanding that that related to the Vanguard accounts. So because she did not think that he had to list it since it was dealt with in another part of the marital settlement agreement, there was no reason for her to say, hey, you didn't write down the retirement accounts because they had been dealt with in another aspect of the marital settlement agreement. The problem was she did not recall that some years earlier there had been different retirement accounts. So, on the question of whether she discovered or should have discovered the omission, the trial court found her testimony credible. And that she didn't recall the accounts from the former employer, that he handled all the finances, that she only discovered them. She did discover them eventually, but when did she discover them? She discovered them when she came to the conclusion that he was cheating her out of her share of the house. And there again, the trial court, and again, this is not an appealable issue, but the trial court found that he had promised to pay her an equalization payment and he reneged on it, right? So when she finally came to the conclusion, hey, no matter what he's promised, he's not going to pay that. That's when she started going through her records. And that's when she went back and found this 2014 email that discussed the aerospace accounts. So I think on these facts, the trial court's finding that it was very credible and reasonable that she hadn't recalled those earlier accounts is supported by substantial evidence. And as long as it's supported by substantial evidence, this court is required to affirm, even if your honors would have come to a different conclusion. And unless there's any questions, I did want to respond to a couple other things here that counsel had mentioned. He said that she had the ability at all times to access this email back from 2014. Well, yeah, except she didn't remember it. If she remembered it, she would have accessed it. And the marital settlement agreement, again, does not specify the specific accounts. If it had said, I'm keeping the aerospace accounts and you're not, she would not have agreed to that. And she specifically testified that she would not have agreed to give up those accounts. He also said that this settlement agreement was approved by a judge as being an equal distribution. Well, that's not correct. No judge said this is an equal distribution. They just said, you've agreed to this and we'll incorporate it into a judgment. And again, I don't think this was a case of buyer's remorse. She was okay with the settlement that they made until he reneged on his promise to give her an equalization payment on the house. And again, the court found that he did do that. Unfortunately, she didn't bring that claim in time. But so it wasn't a case of buyer's remorse and she changed her mind on the agreement. It was a case that she realized she had been cheated, and that's what caused her to start going through the paperwork and eventually find the reference to the earlier retirement accounts.
Anything further?
No, I think that's all I have, Your Honor.
All right, thank you. Rebuttal?
Yes, briefly, Your Honors. Thank you very much. And thanks to Ms. Mazur for her very well thought out argument. Only one problem with that argument. There's a factual misunderstanding on Ms. Mazur's part, probably because she wasn't the trial counsel. She's appellate counsel. The aerospace accounts were not from Mr. Nguyen's former employer. He currently works at aerospace. He's worked at aerospace for the entirety of the marriage, and that's in fact undisputed. So this isn't some archival oh, many years ago, I used to work for this other company that I don't work for currently. It was the company he was working for at the time these negotiations were happening. And it's the company he works for at this very moment and is currently working at. So this isn't something that would be forgotten. And although I agree with Ms. Mazur that this is not a situation in the marital settlement agreement where each of the accounts was specifically listed, neither hers nor theirs. They simply referred to, he's keeping all of his retirement accounts, she's keeping all of her retirement accounts. And as I think, as his honor indicated, I think this goes to the should have known issue. The fact that she has actual knowledge, the fact that she has access to all these records. I think there was some, I would call it, at the very least, an inquiry notice that, hey, we're talking about retirement accounts. In fact, this is a divorce in which the child of the family was already an adult, and in which, as was indicated by counsel, one of the equalization payments that was occurring here was my client's agreement to voluntarily pay for the education of their now adult daughter. That was a factor in her determination.
Your time has expired, Mr. Chabia, so if you want to have a concluding statement, that's fine.
Certainly. My only other quick point is I agree with counsel. This is an appealable order, and I think from a standpoint of best use of judicial resources, it should be treated as such. And the last issue with regard to timeliness, a minute order is not an appealable order. The minute order was issued when it was issued, and it was a far longer time before the final findings and order after hearing. The actual appealable order, which was entered on October 26, 2023, and in which we filed an appeal less than a month later, we think this appeal is timely. We thank the justices for your thoughtful consideration of this matter and wish you a good day.
Thank you both, counsel, and the matter is submitted. The next case is Kuhn versus Sussman. Perhaps I mispronounced the plaintiff's name, Huynh. Yes, come forward, please. On the telephone, would respondent please appear?
Good afternoon, Your Honors. Garrett Daly for respondent Joseph Sussman.
Thank you. Whenever appellant's ready, you may proceed. And start by telling us your name, please.
My name's it's Na Han.
What is happening is that your laptop is covering up the microphone. If you could move it over a little so we can hear you. And would you give your appearance again? State your name again, please.
Yes, my name is Na Han. I'm the appellant in the case.
And you may proceed.
Yes. Well, this is a simple case about an infant and subject matter jurisdiction of the child being between like two different places. You know, the child was born and raised here in California, and his name is Justin. And during the first 3.5 months of life, he lived here exclusively in California. We then spent about 4.5 months in Nevada, back and forth, trying to build a family, but it didn't work, it didn't last, and so then we came back here basically almost permanently. And that was on March 12, 2023. When we returned back here, we made an agreement that showed intent that that the child would be here primarily most of the time, and then he would be 5 days a month in Nevada. And then when we went through the UCCJA jurisdictional trials, the decision came out on November 30th, 2023, that the jurisdiction went to the other party, to Nevada, under the significant connections code 3421A2. And so at that time, it was the trial court ruled a state of Nevada shall have full jurisdiction over this matter, is the final ruling of the judge. So it for those reasons, because it's a final ruling and that we won't, there's no more proceedings here. There was never any custody proceedings here either. This case is definitely appealable, and it's proper in front of this court. So one of the things to look at in regards to reviewing the case is that I believe that the trial court made a legal error, and the standard of review would be under de novo. However, substantial evidence is actually just on the trial judge's ruling. On the trial judge's ruling, we can read on there that there is a whole, just one quote from there could tell you what, in regards to jurisdiction. In this situation here, we're talking about the UCCJA, which has two prongs, home state and significant connections. And a home state is paramount. And home state means the state in which a child lived with a parent for at least 6 consecutive months immediately before the commencement of a child custody proceeding. In the case of a child that is less than 6 months of age, the term means the state in which the child lived from birth. A period of temporary absence is a part of the period. Substantial evidence shows that from the trial court's ruling, quote, from the date of birth on July 2nd to September 29, 2023, the minor child spent 3 months in California, 5 months in Nevada, and 6 months in California. The requirement is 6 months away. Under the home state clause is that a period of temporary absence is part of the period. So just with that one quote from the trial court's ruling, identifying the duration that there was 3 months since birth here for the child, and then 5 months of temporary time away, and then 6 months here back again in California. Home state alone is, California is the child's home state with a temporary absence, is what I was wondering. And then I did a request to leave of a reply brief. When it was due in January 2nd. It was right around the holidays, and I missed it. And when I got your letter just more recently about the notice, about doing the briefing, I thought it would be, since I'm not very good at speaking, I thought it would be helpful that I wrote it all down and stuff. So I did a request to leave to file today. If the justices would like to review it, that it speaks more to rebuttals that was from respondent's brief. The primary thing that happened between the opening brief and the respondent's brief, I think may seem really confusing, because to me the case was very simple. It was just a home state situation, and it had some temporary time away, and that was it. But when you read the respondent's brief, it gets very confusing, because the procedural posture has been completely changed. The majority of the answers for respondent were basically he was first in time, but yet respondent was not first in time. It was actually respondent's second petition during a time where there were no orders from California or from Nevada. So in the initial petition, or the petition that is on appeal, or that brought the case to Nevada, is the March 15, 2023 petition in Nevada. However, respondent didn't mention that there's also one on January 3rd, 2023, on the child's 6-month birthday, which happens to align with the UCCJA 6-month home state statute too. But he quickly dismissed that within 6 days voluntarily and with prejudice. So with that petition and that he had voluntarily dismissed it, it waives any claims to being first in time. But while you read respondent's brief, to block appellate review, basically it was always that Nevada is first in time, so that's that. He hardly touches upon the home state statute or even the connections that that we have or California has versus Nevada. So I wanted to share that, and then beyond the quote alone, although the California trial court ruled and ceded a jurisdiction to Nevada, there was substantial evidence all over the ruling. Everything from that one quote I shared that basically identifies exactly the duration and the temporary absence. But it also states, like, for instance, a time away where the child was born in California, the parties resided together in California. And then on March 12th was when we officially came back to California. And then there's quotes also that that share about us, that I had maintained my residence, and that when we came back to California, it's the same exact residence as well. It's a lease that I've had since 2019, and the same place that I still live in today, as well too. With that, and so there's a substantial amount of evidence on just the trial courts, and as well as in my opening brief, where I use raw evidence. I just went straight to the lease and the pictures, or direct from there. And more recently, just to keep it really simple, without going through all that, was I just used the words that was in the trial court's ruling that identified home state. And our case is very similar to Schneer. And for Schneer, it was a very similar where it was a child that was in California, was away to Florida for 4 months, and then came back. And a part of that too was that the parent remained in the state and continued to. And a big part of that was the intent as a part of keeping their residence as well too. And our case parallels that very much so as well. And so because that the case can be explained by both, the substantial evidence can be explained both by just direct evidence and facts, and then also just direct facts from the findings in the ruling from the trial court. So whether it be de novo or if it is under substantial evidence review, always California is the child's home state. And that's pretty much what I wanted to say.
All right, thank you. You have 3.5 minutes remaining for argument. The respondent?
Good afternoon, Your Honors. You have asked us to address 3 questions, so let me first tackle those. The first question is whether this court has jurisdiction to review the Nevada order. And the answer to that is fairly straightforward. It's found in Family Code 3426, which says if the court, this court, determines that a child custody proceeding has been commenced in a court of another state having jurisdiction substantially in compliance or in accordance with this part, and that, of course, is Nevada, the court of this state shall, again, mandatory, stay its proceeding and communicate with the court of the other state. Now, that was done, and it was done in a very extraordinary way. Normally, it's done with a phone call. This time, it was done with a joint, coordinated, simultaneous 4-day hearing, where the two courts held the hearings with multiple attorneys in both states before the decision was made. So there was clearly communication between the courts. The statute continues. If the court of this state, of the state, having jurisdiction substantially in accordance with this part, and that is Nevada, does not determine that the court of this state is a more appropriate forum, the court of this state shall, mandatory, dismiss the proceeding. Now, appellant admits that the custody action was first commenced in Nevada, and she has not argued that the Nevada proceeding was not substantially in accordance with the UCCJEA. The word accordance only appears once in a brief in the last line, and it has nothing to do with this statute's totally unrelated use of the word. So again, in fact, we had the two courts not only communicating but cooperating to determine which state was the appropriate one for UCCJEA determination. What she argued in her brief, and she's argued this afternoon, is that the two judges erred in finding Nevada had substantial and weightier contacts with the child than California. And her arguments are, and she's just restated them here this afternoon, is that California was the child's home state. The child's contacts to California were weightier. Nevada, she actually hasn't argued this today, but she argued it in her brief a great deal. Nevada was an inconvenient forum, and that father was forum shopping. Now, of course, these are all purely factual determinations, which both judges strongly resolved against her. Now, as we point out in our brief, there is a plethora of evidence supporting the two judges' determination. Appellant has just said, oh, there's no substantial evidence supporting it. Well, there isn't any in her brief because she ignored all of it. That's one of the questions I'm going to address in a second. She ignored all of the supporting evidence, relying only on evidence that she felt supported her argument. Of course, the problem with that is even though that's not permitted, but the evidence she cited was not even in the record because it's all in her declarations, which had been excluded from evidence. Since there's no dispute, Nevada is exercising jurisdiction. It was first in time. It's exercising jurisdiction in accordance with the UCCJEA. The UCCJEA requires California to dismiss the proceeding, which is exactly what happened, and it's exactly what the law requires. Now, to me, the more important point is that at no point does appellant explain what possible relief this court can provide. Hypothetically, were this court to order the trial court to reverse its decision, what effect would that have in Nevada? The answer is none. The case law is clear. Appellant's remedies lie in Nevada. And we quote Siegel v. Fishbein in our brief, and it says Family Code 3422 unambiguously gives the decree state sole power to decide whether jurisdiction has been lost. This court has no jurisdiction to order the Nevada court to do anything. And if it were to attempt to do so, it would contravene the very essence of the UCCJEA, which was enacted to avoid jurisdictional disputes between states. So her action was properly dismissed, and of course, that dismissal should be affirmed. The second question is whether she has forfeited her appellate claims by failing to cite evidence supporting the California court's finding and explaining why such evidence is insufficient. And if I could, I was trying to figure out how to explain that, and the answer is, to me, was a Socratic syllogism. You know, major premise, minor premise, conclusion. Major premise. An appellant's opening brief is required to set forth all material evidence on point, and it cannot rely simply on facts favorable to the appellant. And when the opening brief does so and ignores evidence favorable to respondent, the appellate court can treat those issues as waived and presume the record contains evidence to sustain every finding of fact. So that's the major premise. The minor premise is she only set forth in her declarations, which again were excluded, set forth facts from there and ignored 100% of the evidence on which the judges relied. That's important. She did not quote a single fact that the judges relied upon in her brief. So the only logical conclusion, major premise, minor premise, conclusion, she has forfeited her appellate claims. The third question is really the more important one, and that is whether her failure to comply with the rules of appellate procedure by failing to fairly summarize the evidence or present cogent arguments, and her citation to non-existent cases warrant sanctions. Now, to me, these are really three questions within that one question. There are three subparts. First, the remedies for her failure to comply with the rules of evidence, the rules of appellate procedure. The remedies are well known. And her failure, which we discussed, is she relied on excluded evidence. She failed to cite any facts on which the judges relied and really failed to present any meaningful arguments in her brief. For example, what relief could this court give? I mean, that's a fairly fundamental point that she should have developed. What would happen if this court were to decide to say, oh no, trial court, you erred? Because it's also important, let me just digress for a second. She keeps saying California ceded jurisdiction to Nevada, and I think those words were used. But California didn't really cede jurisdiction to Nevada. Nevada had jurisdiction. What happened is California agreed, because in order to cede jurisdiction, you have to first have it. And California never had jurisdiction. Nevada was first in time. It was exercising it in accordance with custody, in accordance with the UCCJEA. California never had jurisdiction, so technically it couldn't cede it. All that happened was that the judges discussed it, and they agreed Nevada was the better place. But again, it's important to remember that Nevada had jurisdiction, California never did. But anyway, I digress. Let me continue. So again, at the very least, she's waived any argument that the findings were not supported by substantial evidence. And you just heard it again this afternoon, her challenges are 100% based on her disagreeing with the judge's factual findings, all of which are supported by substantial evidence. The issue is resolved. Now, the other remedy, of course, is dismissal, which is what we have requested. And that's only used in egregious situations, and I think this certainly qualifies. Now, the more pressing question, which I hope this court will address, is what are the ramifications for the misuse of generative AI, artificial intelligence, in attempting to mislead this court by relying on non-existent legal authorities to support what are really bogus arguments. This is crucial because AI is transforming the legal system. It's the most important development in law, really, practice of law since the internet. But as appellant has demonstrated, it can be misused. She filed not one but two briefs in this case, with the majority of the authority she relied upon being hallucinations. Now, had they not been spotted, identified, this court might have been misled, and it could have created bad precedent based on phony fraud, really. This was a fraud on the legal system. Now, California attorneys, we have virtually no guidance on the use of AI. The State Bar has given us some very general rules, but basically all they say is it's your responsibility to verify the accuracy of the text that is generated by generative AI. But the question is, are there penalties for misusing artificial intelligence? And if so, what's the nature and scope of those penalties? What factors should trial courts consider in administering them? For attorneys, of course, one of them would be a referral to the State Bar. But what about self-represented litigants like the appellant here? We need guidance, and hopefully this case can provide a vehicle for you to address those issues. I just would note one thing, and that is appellant was represented by some really good lawyers, at least two of which were certified family law specialists, and one of them was certified appellate specialist. So she knew where to get help if she wanted it. Now, the final question, final part of the third question is really, should Flaherty sanctions be applied? Now, the respondent has incurred over $60,000 in fees and costs associated with this appeal. Appellant has raised no plausible legal arguments. She did in her briefs. She didn't today. Any reasonable attorney would agree that this appeal was indisputably without merit, totally and completely. In short, in my opinion, it had no socially redeeming value, and sanctions are appropriate. One final comment, and that is the entire appeal is based on the assumption that California can claw back jurisdiction from a state which is exercising jurisdiction in conformity with the UCCJEA. Now, again, as I said, that runs entirely counter to the entire purpose of the UCCJEA. There's no dispute that Nevada was first in time. There's no dispute that it's exercising jurisdiction. It has not been argued that it's not doing so in conformity with the UCCJEA. No mechanism exists for California to claw back jurisdiction, and the purpose of the UCCJEA is to avoid exactly these type of unseemly jurisdictional disputes. So I ask that the order be affirmed and that appropriate sanctions be applied. Other than that, we would prepared to submit unless there are any questions.
I'm not hearing any questions, Mr. Daly. Thank you very much.
Thank you, Your Honor.
You're welcome. Appellant may rebut if you have any more arguments. How do you pronounce your name? Come forward, please.
It's Nahan. I'm there. Yes.
Yeah, Ms. Han, you may proceed.
Yes, I have a few rebuttals. First of all, respondent keeps going over and over again about that they were first in time. In order to be first in time, that goes actually to 3426. In order for 3426 to apply and to be able to trigger that, Nevada must have already been exercising valid UCCJEA jurisdiction at the time. There were no orders, there were no findings, there were no proceedings during that time. So just because a respondent is saying that he is having, that there are proceedings in Nevada and that they are having jurisdiction right now, does not bar this court from reviewing, nor does it affect the appealability of this appeal. Because if they, the key part is that it has to be a valid UCCJA jurisdiction. So if California is the home state of the child, then first in time would be irrelevant to all this. And beyond that is that they aren't even first in time, because it's their second one as well too. So in addition to that, the final jurisdictional ruling on November 30th, it was on subject matter jurisdiction. We went through the UCCJA, we went through home state, we went through significant connections, we went through inconvenient forum. That is not one where you go to first in time on for. In regards to, like, respondent was saying earlier that there wasn't evidence. I mean, I believe the evidence from the court, from the rulings, is very significant and very material as well too, and that you'll find through, if you can have the time, justices, the request to leave the reply, I left in more detailed notes in there, but more specific, like one particular thing is like, respondent said that my counsel conceded to that there was no home state, and he used a quote and he took it out of like context on what it was. He selectively chose my counsel saying there is no home state. There is not disputed by either side. The record, however, though, it demonstrates that actually counsel was not talking about concessions or conceding. He was actually explaining to Nevada Judge Perry that she had asked a question, isn't it jurisdiction based on where the father lived, quote, and so counsel was explaining, no, it is not, and that he went to clarify that neither side was making that type of an argument, and he immediately pivoted to inconvenient forum, which is the next prong after connections, to explain, and he was arguing for California, not against California. So just in a prime example there, where it's all on paper, you could look and go to the records and see who is speaking the truth here, where are the facts, what is on the record, and what follows the law. You will see that the procedural posture of this case is correct. It's the initial jurisdictional determination of an infant. It is not first in time. This is not a custody matter. We're not talking about fixing orders. And in regards to sanctions.
Just a minute.
Oh, sorry.
Your time has expired, but you may finish your thought.
Oh, thank you. Oh, I was just saying, in regards to sanctions, just being a pro-per and trying to navigate through two different jurisdictions and a complex case where it's actually really simple, but it's become very complex because of extra burden, I try my best to cross all my T's and do all that stuff. It's definitely not intentional. There were two AI or hallucinations that was in there that and that was in the inconvenient forum citations, which is not like even one that I'm discussing here today. So I just wanted to also apologize for that. I didn't catch that one, and yeah, I'm sorry.
Thank you, Ms. Hun. Thank you, Mr. Daly. Your matter is being submitted. The last two cases on calendar this afternoon share some similar names. So when I call the next case, I'm going to give the last four numbers of the filing number. This case is conservatorship of the person in estate of M.A., and the last four numbers are 3437. And we have J.S. appearing for the respondent and Eric Becker appearing for the appellant.
Your Honors, this is Dave Shaver on the matter number 4.
So I'll call yours in a next, but we have another case before yours. Is J.S. here? First name Jodee? Yes. Over here at the respondents table, please.
I'm sorry, I misunderstood you. I thought,
That's all right. Would you give your appearance, please?
my name is Jodee Sussman. I am the respondent in this appeal.
All right, Ms. Sussman, we received your request under the Americans with Disabilities Act, and we're about to rule on your request.
Yes, ma'am.
First, your advocate may sit next to you and may take notes. Second, you may speak as fast or as slowly as you need to speak, and as much or as little as you need to speak. Third, you may not record the proceedings. However, I want to tell you that these proceedings are being recorded and they will be available to the public. And lastly, if you need to take a short break, just let us know. And with that, appellant may proceed. You may sit down.
Yes, ma'am.
May it please the court. Good afternoon, your honors. My name is Eric Becker, and I represent the appellant, Richard Huntington, a licensed private professional fiduciary who served as court-appointed conservator of the estate of Marty Adair. This case is not about the complexities of the underlying conservatorship, although there were many. This appeal presents a straightforward question of procedural fairness and the integrity of our probate process. Can a trial court base its ruling on unsworn statements made during closing arguments by individuals who were not parties to the petition and who waived their right to object? We respectfully submit that the answer is no. Let me briefly walk through the relevant background and then preview the arguments that we have expanded upon in the briefing. Mr. Huntington was appointed conservator of the estate of Marty Adair in 2019 pursuant to a settlement agreement between the relevant parties and their counsel when competing petitions for conservatorship were pending before the trial court. He dutifully served from his appointment as temporary conservator of the person and estate until he resigned pursuant to another settlement agreement. He also acted as trustee of the bankruptcy estate when bankruptcy was required to protect the conservatee's assets. As required by law, Mr. Huntington filed accountings, the first of which was litigated and approved in 2021. And the second and final account, which is the subject of this appeal, along with a petition for attorney's fees related to the representation of Mr. Huntington in his capacity as conservator, supported by a declaration in support of attorney's fees, filed in which Mr. Huntington was requesting court-approved attorney's fees as compensation for work performed during the subject accounting period. These two pleadings, the second account and the Becker declaration, were placed on calendar in the trial court with ample notice to all interested parties. At the first hearing on this accounting and petition for fees, which was November 2nd, 2022, the court ordered that any objections be filed by December 15th, 2022. And later that deadline was extended to March 27th, 2023, making clear that any objections not filed by that date would be deemed waived under California Rules of Court Rule 7.801. Despite having been given repeated opportunities to object, no party filed a written objection to the second account, and only one party, Judy Evans, filed a written objection to the petition for attorney's fees supported by the Becker Declaration. In a joint pretrial status report signed by all participating parties and attorneys, including the respondent before this court, Jodee Sussman, it was explicitly confirmed that the second account was unopposed and the fee petition supported by the Becker Declaration was contested only by Ms. Evans. The parties agreed and the trial court confirmed that the matters would be submitted on the pleadings only, with closing arguments limited to legal interpretation, not evidence or new testimony. Not testimony or new evidence. Unfortunately, that's not what happened at trial. At the closing arguments, this agreement was upended Despite their failure to file objections and despite the court's own prior orders, the court allowed Ms. Sussman and another non-party daughter, Trudy Adair Warner, to deliver extensive, unsworn statements. The court invited them to speak, soliciting their inflammatory comments and even allowing a video of the conservatee, Marty Adair, to be played in open court for the first time. The parties had been admonished during this closing argument hearing to not object during closing arguments, and therefore appellant did not object in defiance of said admonition, not because he agreed with the process, but because he reasonably relied on the court's repeated assurances that no new evidence would be accepted. There had been no witness testimony, there was no cross-examination, and there was no verification of any of the assertions made during these closing arguments. Nonetheless, the trial court's final decision relied heavily on these last-minute statements that were never subject to cross-examination, evidentiary foundation, or due process. And in the ruling, the court drastically reduced attorney's fees, implied misconduct by the conservator, and ordered appellant to file declarations related to issues that had never been previously raised in the proceedings, but came up only for the first time during the daughter's closing statements. This appeal is grounded in two core legal errors, both of which constitute an abuse of discretion and, more importantly, a denial of due process. First, the court improperly treated non-parties who had waived their objections as formal objectors. Under Probate Code Section 1043 and Rule 7.801 of California Rules of Court, only timely filed written objections make a matter contested. That rule was ignored. Second, the court improperly treated unsworn oral argument as evidence, in direct contradiction to longstanding precedent and to the parties' stipulated agreement. This is not harmless error. It materially altered the outcome, and the court expressly stated in its final statement of decision that it relied heavily on the daughter's oral statements in weighing credibility and in making opinions as to Mr. Huntington's professionalism and in reducing compensation to his attorneys. Appellant does not seek to re-argue the reasonableness of every line item in the fee petition. He seeks only a fair process where verified pleadings and actual evidence control the outcome and where the rights of the parties and non-parties are respected as defined by law. Your Honors, fiduciaries like Mr. Huntington are essential to the probate system. They take difficult cases and judges that the judges entrust to them. They are bound by law and by their duties to the estate. When a court turns around and punishes one of them based on last-minute arguments and waived objections, it sends a chilling message, not only to him, but to every fiduciary asked to serve. Accordingly, we respectfully request that this court reverse the trial court's decision as to the second account and petition for fees, vacate the improper findings that relied on inadmissible statements and unauthorized objections, and remand the matter for reconsideration consistent with proper evidentiary standards and due process protections. Thank you, Your Honors.
Thank you. You have 9 minutes remaining.
Thank you.
Respondent?
Just so I'm clear, is it okay if I first ask about the objections that he just filed while we were sitting in this courtroom? Do I need to address that?
Would you move your laptop so that it's not covering the microphone, please? And give us your appearance one more time, if you would.
I'm
That
sorry.
means give us your name.
My name is Jodee Sussman, respondent.
Thank you. You have this time, Ms. Sussman, and you can use it any way you want. And we're not going to give you any directions as to what to address or not address.
Okay. And do I have 5 minutes? Because on the...
You do, but if you need a few more minutes, that's fine.
Well, it said asterisk and a 5.
That's,
So I didn't know what
the
that meant.
5 minutes, the asterisk means that the rules of court were not followed by a request for a certain amount of time, so the default number is 5 minutes.
Yes, ma'am.
If you need a little more time, that's fine.
Thank you. For the record, I'd like to object to the petition that the loss of Eric Becker filed on behalf of Richard Huntington today at 2 o'clock. As Richard Huntington's applied to the June 10th, 2025 letter from the appellate court that states the following: if you intend to argue any authorities not cited in your brief, you must so advise the court in writing and all the parties before in-person oral arguments, which for the record I submitted as required by this honorable court via the true filing, the required letter, and inform the court, all parties and attorneys of record, that I will be citing additional authorities. That's all I'd like to say about that. I did believe that I filed what I was told to do. Good afternoon, Honorable Appellate Court. I am the respondent in this case and the case number G063346. May it please the court. I do wish to apologize for most of my respondent's brief having a little too much quoting of the trial.
Just a minute.
Oh, yes, ma'am.
This is 3437, and you said 3346.
I'm sorry. I meant I'm not only this case, I'm also saying pretty much the same thing for the next case, because the cases are not being heard together, but they cover the same material.
You may proceed.
Thank you, ma'am. I do wish to apologize. I know a lot of this is already in my respondent's brief, and that I heavily relied on what the judge said. I was impressed by how comprehensive, how professional, and how detailed the trial court statement of decision is, including how it reached that decision. It's so comprehensive that I can't believe anyone would seek to call the trials court decision into question, especially by the claims being made by both of these appellants, as I don't see either appeal brief as having meritorious claims. It appears they simply do not like the trial court's decision, but lack lawful reason to appeal. In the 71 pages of the trial court's comprehensive final statement of decision, it's stated repeatedly for each section as they related to the conservator's attorney's fees and the guardian ad litem fees, that the trial court did not consider any closing arguments or statements to be evidence, and only considered those arguments that had valid, admissible evidence to back them. From the outset, I would like to point out that the additional authority I cited, Baytieh versus Bank of America, 1998, 67 Cal App 4th 779 784 to 785, and the California Rule of Court 8.883 A1A speaks strongly to why the trial court's decision should stand. There is no meaningful legal analysis given in the appellate's opening brief, and without meaningful legal analysis of an issue, it's considered waived on appeal. Meaningful legal analysis when it comes to both appellants claim that the trial court used closing statements or arguments as evidence is not even possible when no specific closing arguments or statements is identified for analysis as to whether or not the court did indeed use it as evidence. This is especially true when the trial court, in separate sections, identifies its standards for determining the reasonableness of the fees being petitioned for or claimed, as payable by the estate of the conservatee. See the statement of decision at page 37, lines 1 through 9, for its evidence, standard, and considerations of the guardian ad litem's fees as well. I would also like to note that the statement of decision at page 24, footnote 8, describes the standard of proof it found for the evidence supporting the objections to the guardian ad litem's fee petition, which was clear and convincing, despite noting that the fee petition itself did not have to meet a clear and convincing evidence standard. It only requires the lower court preponderance of the evidence standard to support a fee petition claim. While the appellant guardian ad litem expresses confusion over this matter, it's unclear why the trial court was stating that the fee petitions required a preponderance of the evidence standard of proof. But in deciding to reduce fees based on objections made, the court found the evidence for those objections to be clear and convincing, thus being greater in evidentiary strength than what was used to support the fee petition submitted. The statement of decision couldn't be more clear about this. And it is curious that the guardian ad litem appealed the trial case's decision without fully understanding it. For how could it be an error took place if it didn't understand what the court did? No meaningful legal analysis is possible by a party that doesn't understand what was done. Meanwhile, in the final statement of decision in regards to the fees being claimed by the law office of Eric Becker, allegedly on behalf of the conservator, it is found at page 44, lines 6 through 13. The trial court specifically states it did not rely on arguments as evidence as claimed in their opening brief. Argument B at page 29. This is repeated by the trial court in its statement of decision at page 49, lines 2 to 3. The court is not accepting as true anything stated in closing arguments by any party or attorney unless such statements are supported by admissible evidence. I'm not sure how the trial court could be any more clear that it is expressly did not use closing statements or arguments as evidence, as they had to be supported by admissible evidence, which indicates that they themselves were not evidence. As the appellant, Mr. Becker, is claiming in argument A that objections were waived. That can't hold the mustard in light of Probate Court 1043, which permits objections to occur orally at any hearing affecting a property interest by the person so affected, while objections under Probate Court 2622 might be considered specifically waived as they are required to be in writing and in absence of any hearing. It is irrelevant when any party with a property interest appears at a hearing that might affect that property interest under Probate Code 1043, and that cannot be waived except by lack of appearing to orally object. That the respondent appeared and orally objected isn't proof of an error in law by the court due to constraints on Probate Code 2622 objections. It's more accurately proof that respondents' objections under Probate Code 1043 and thus no error in law occurred. It is important to take note here that even absent of objections, the appellant's fees have to be reasonable, and the courts clearly stated that with or without the objections, It conducted an independent analysis for the reasonableness of those fees being requested, so even striking the objections would not necessarily lead to a different outcome. To switch now to appellate guardian ad litem's argument A and F. Neither.
Are you now talking about the next case?
Well, I kind of meshed them together because it's the same panel and it's so much, it's so redundant. They're both together. Would you like me to
I would like you to
stop?
finish on this case, and if you've already gone over twice the amount of time you were allotted.
Oh, yes, ma'am.
But if you need to say something else for this case, and then we're gonna hear from Mr. Becker to respond to
Yes,
whatever
ma'am.
you said, we will submit this case at that point. Then I will call the next case.
Yes, ma'am.
And the other attorney will have an opportunity to argue for the next case.
I'm gonna go and just go ahead and finish this. I'm gonna talk directly to you. I know I should be reading this, but the fact is, what that judge,
Can I have a break a moment? She's getting really nervous and it's gonna make things, I apologize for jumping in, but she just.
That's okay. We can handle it, thank you.
that judge put so much time into this case. And what I said was nothing different than the oral or the written objections I made. And yes, we were in front of Judge Bells for that November 2nd hearing, but Mr. Becker knew full well that Judge Bells had already been disqualified. In that hearing, I said I would not be doing written objections to his fees because the last time I did, that drew a motion to compel that he failed to file and serve me. There are reasons why I did not file written, but our agreement was, and Mr. Becker and his entire firm knows full well, our agreement was I would not waste any more of this court's time. I would orally say my piece and say what my objections were, and that would be it. But in actuality, nothing I said has been different than what I've said for the last 5 years. And I humbly request that you uphold that judge's decision, well-thought decision, and don't be confused with all the red herrings and everything else. I do believe in my brief I outlined my position, and I thank you for my ADA accommodations and for your consideration in this case.
Thank you. Mr. Becker, anything further?
Yes, just briefly, Your Honors, may it please the court. In response to the respondent's statement that she had informed the court that she was not going to be filing written objections, it was another judge who specifically informed her and instructed that objections would not possibly be waived, but would be waived were they not filed by dates certain, both in December and then by March. Those dates were not met. Written objections were not filed. The trial judge, Judge Baytieh, when he did have his last pretrial conference, informed the respondent that she may not be entitled to even oral argument at all because she was not a party and had not filed objections. And he had requested of her that by the first day of trial to put a written request before him to persuade him as to why she should be allowed to present oral argument. The respondent indicated to him on the first day when he did inquire that she hadn't filed a written request, and despite that, despite appellant relying on the court's rulings that these objections would not be allowed, The court did allow these closing arguments. I believe each daughter of the conservatee spoke for approximately 1/2 hour. The written fee objection, or the written objections that were filed by Judy Doan, who is the only party that did file written objections to the petition for fees, were very tailored and very narrow in form. And the statement of decision went far beyond and did rely on the half-hour closing statements made by the daughters, to the point where he made a further order that we provide signed declarations to inform him as to allegations that were made for the first time in the closing arguments related to statements that were purportedly made by myself and my partner as to whether or not the daughters had standing in federal court. That was never raised before in any pleadings. It was raised in these closing arguments, and for the first time, I'm hearing all these allegations, and not only am I hearing them, but then the judge in his statement of decision is making further orders that we address these allegations. So despite what was said by the respondent, some of the stuff was brand new for the first time. We were caught by surprise, and we really were denied due process because we weren't allowed to cross-examine. We weren't allowed to object. We had to sit there and listen to these closing arguments that were extremely questioning the professionalism not only of the conservator who had served and saved this estate millions of dollars, but as to counsel as well. We were personally attacked, and we took the high road, and we did what we were supposed to do according to court instructions, and the final statement of decision seemed to have gone far beyond what we were expecting and what the rules had been agreed upon by stipulation and by order. So with that, I rest, Your Honors.
Thank you. Mr. Becker, Ms. Sussman, thank you both for your arguments. The matter is submitted. The last case on calendar this afternoon is also the conservatorship of the person and estate of Marty Adair, and the last four numbers in this case are 3364. And whenever appellant is ready, you may proceed.
May it please the court, my name is Dave Shaver. I was the court-appointed guardian ad litem for Marty Adair, and my appeal addresses my fee petition for fees in service as the guardian ad litem. I have the same arguments on the trial process that attended to the fee petitions. It's not uncommon in probate and trust, and even in civil, to simplify fee motions by agreeing to submit on the pleadings and do oral argument to streamline the process, allow the court to rule. And that's what was done on this case at a time when we had a judge on the case that was familiar with it. Judge Baytieh was brought into probate late. And as far as I know, this might have been one of his first probate cases. So he acknowledged the fact that we were doing this according to what the parties had stipulated to. I'm not going to spend a lot of time on that. I briefed it. It was argued in the prior appeal, but I have the same issues relative to how the hearing was handled from an evidentiary and due process standpoint. My issue is kind of a unique issue because it appeared that the court punished me as guardian ad litem and reduced my fees based on a ruling that he didn't feel I did my job as the guardian ad litem, as opposed to looking at a particular entry and saying, I think you spent a certain amount of too much time on that and I'm cutting that. There was a couple of entries like that. I'm not disputing that. The majority of my bill that was cut directly related to the court's finding that as a guardian ad litem, I didn't do my job, which I take exception. I went back and looked at my brief, and several times the one sentence that kind of summarizes what a guardian ad litem does is a guardian ad litem's duty is to determine and protect the interests of the ward, in this case Marty Adair, by investigating relevant information and making recommendations to the court. As the guardian ad litem, I am not Marty Adair's attorney. I'm there as a court agent to serve for her best interest. Ms. Adair, Marty Adair, did have her own attorney, public defender, Holly Galloway, who was a very competent attorney and represented her interests well. In addition, one of the parties to the conservatorship was one of the daughters and was represented by a counsel as well. So going through each of the issues that I felt addressed the issue about quasi-judicial immunity. There's not a lot of case law on it. One of the lead cases, McClintock versus Michelle West. But other than that, there's not a lot of clear case law. As far as I could tell, there's been no case that addressed my issue about whether or not I have certain protections for doing discretionary acts as a guardian ad litem. So one of the issues in this case was this was a big, large dollar amount estate. It was a real estate rich, cash poor estate. The real estate property was very unique, worth a lot of money. It had a hybrid. It had a entertainment business that Ms. Adair was running for like weddings, and they were doing proms and grad night type things. It was a very unique building, and I think I commented on it in my briefs and in my closing argument. Unfortunately, over the years, that particular property had a lot of code violations. So by the time I was appointed, I did attend an early meeting with the bankruptcy attorney. By the time I got involved, there was already a bankruptcy in place. And my question was, why do we need a bankruptcy? And I spent several hours with the bankruptcy attorney and all the attorneys figuring out what the problem was. And the primary issue is, what are we going to do with this real estate property? If Ms. Adair is going to go under conservatorship, she's already established that she couldn't run a business. She already got herself in financial trouble. How are we going to get her out of this? So the big issue was, are we going to sell this business and this property to provide for her care, or are we going to keep it as a running interest? Well, eventually the city kind of answered the question by issuing code violations that had to be addressed. So I feel I was well within my discretion to go out and look at the property and make recommendations, which I did. I made a recommendation that they have a structural engineer and a general contractor and provide professional input as to what it's going to cost to put this property back into place where maybe you might be able to do a business. And mind you that the middle of all of this, we're in the middle of COVID, and she has a business where people show up, which would be barred. So I'm a little embarrassed because at some point in time, I felt maybe my background was not clear, so I did provide a declaration. I'm a 40-year lawyer. I was a 35-year lawyer at the time. About 20 years of my experience had to do with representing government entities. I've represented the City of Santa Ana, County of Orange, Department of LA Airports, the Sheriff's Department of LA, City of Huntington Park, City of Redondo Beach. During my tenure representing the City of Santa Ana, we did do some code enforcement. So I am very familiar with building code violations. And in fact, I knew the city attorney at that time. I talked directly with the building code people to get a clear idea of what exactly the problems were. And I made a recommendation. And my recommendations in my first report to Judge Johnson, I think, was on the case. No one objected to any of this. Those reports were then taken by the bankruptcy trustee and the bankruptcy attorney and approved by them. The family was not happy with the recommendations. They thought somehow I was not acting in the best interest, but I'm acting as my service as the GAL to the court to provide relevant information for the court's consideration if we're going to litigate this.
All right, so what error did the trial court make in deciding the amount of attorney fee to award?
With that specific issue?
For all the issues, what was the basic error that the trial court made?
I don't think the court understood one, all due respect to Judge Baytieh, I don't think he understood what a GAL's job was. I don't think he understood what my job was.
Well, I'm not asking for the reasons for the error, I'm asking for the legal error that the trial court made.
He made a legal error in deciding that my discretionary decision, in this case, with respect to inspecting the property, making a recommendation.
Well, did the judge make an error in counting up the attorney's fees? That is, in deciding the evidence, was there some error regarding the evidence? Was it a discretionary error? Was there an abuse of discretion? Was there a legal error?
I think it's a legal error because, for example, I spent 4 hours at the site inspection, he cut it to 1. On a basis that he didn't think I should have been doing that. And I, in my opinion, I have quasi-judicial immunity to investigate and make a recommendation. I made the call as the GAL that I needed to go out there, take a look at the property. I made the decision to recommend 2 construction professionals that ended up getting used, and they came up with a huge damage. I already knew what the damage estimates were gonna look like. I just recommended you need to get professionals involved. So I think it's a legal issue because if it wasn't a account like, well, I think you spent, I could totally, Your Honor, if it was 4 errors and he came back and said, you know, Mr. Shaver, I think you should have only spent an hour. That's a different issue. That's not what he decided. He just decided, you didn't do your job as a GAL. I didn't like the fact that you went out and inspected the property, so I'm gonna punish you. So I think that's a legal issue that this court can decide de novo, if that was the question.
Anything further?
So the next question is whether or not Marty Adair had capacity. And there was a big issue made by the fact that at the time that there was like 120 days, you didn't go see the ward for 120 days. I don't think the court appreciated the fact, literally 16 days after I got appointed, there was an MSC. In civil, in family law, in probate, it's not uncommon to have an early settlement conference to see if you could sell the case where you spent a lot of money. That's what happened in this case. So already by that time, I already had the investigator's report. I had two separate doctors report, or their psychologists, Multaney and Kang, and that all indicated that she had impairment, and there were issues suggesting that needed a conservatorship. So at the settlement conference, Marty Adair is represented by public defender. Everyone agreed at that time that they wanted to do the conservatorship. I was not going to stand in the way and say, oh, by the way, I need to go see her independently. So it's within my discretion, I approved the settlement. So several months go by, and you can even look at my billing. I think I had a whole month and a half where I didn't bill anything. From my perspective, my job was pretty much done. Until about January, there was a filing to set aside the conservatorship, which is somewhat unusual, because based on the evidence and the settlement, the magic question was, what's the grounds for setting this aside? So I went back and looked, and the attorney at that time for Joan, the other sister, brought forth an expert psychologist, Dr. Walsh. First time he saw Marty Adair was in January of 2020. So I was actually at a hearing, and I was asked, would you interview him? And I said, sure. And he said, how about now? He's up in the cafeteria. I went up and met with the doctor. Listened to what he had to say. It's in my report. I made a recommendation. I didn't say, you know, Your Honor, she should be declared incapacitated. I made a recommendation for either a HAPS review over UC Irvine or Dr. Mora, who is a psychiatrist and a medical doctor. And they ended up stipulating to it. No one objected to my report. Everyone stipulated to the examination by Dr. Mora. They didn't like the results. So going back to Your Honor's question about, I felt like my fees were cut because the court didn't like my recommendation for a 730 evaluation and recommended 2 doctors. I didn't declare they had to go either one. I just said, I think this would, if we're going to litigate this issue, I think the court's going to need this information. Everyone agreed, we got the information, they disagreed. So from the quasi-judicial immunity protects me from being punished for deducting my fees related to that particular activity. So, and the final thing, and I filed a objection to Mr. Harvey filed what's a petition for substituted judgment, where they went to create a separate trust for Marty Adair. Except for in this particular instance, they went to disinherit, I think, the son. And in my opinion, based on the law, is you were not allowed to do that. Had discussions with Mr. Harvey about it. That time they were looking to move Marty Adair to Texas. I said, why don't you wait till you get to Texas, address the issue there, the whole case gets transferred, why would you have Orange County decide it? You end up filing a petition, and I did file an objection to that. So, I have nothing further to add unless the court has any other questions.
I'm not hearing any, and Mr. Shaver, you have 2.5 minutes.
Thank you.
Respondent?
I'll kind of pick up where I left off, but I do believe, according to the paperwork, I had 15 minutes to respond to Mr. Shaver.
That's correct.
Okay.
I can't hear you.
Oh, sir, my name is Jodee Sussman. I am the respondent and proper in this case. I already told you about the statement of decision, and I believe it should stand. In the 71-page trial comprehensive final statement of decision, it's stated repeatedly for each section as they related to the conservator's attorney fees. And I think that also applies to Mr. Shaver as the guardian ad litem. Meaningful legal analysis when it comes to both appellants claiming that the trial court used closing statements or arguments as evidence is not even possible when no specific closing argument or statement is identified for analysis as to whether or not the court did indeed use it as evidence. This is especially true when the trial court is in when the trial court in separate sections identifies its standard for determining the reasonableness of the fees being petitioned for or claiming as payable by the estate of the conservatee. See the statement of decision at page 37, lines 1 to 9, for its evidence standard and consideration of the guardian ad litem's fee petition. I would also like to note that the statement of decision at page 24, footnote 8, describes the standard of proof it found for the evidence supporting the objections to the guardian ad litem's fee petition, which was clear and convincing despite nothing that the fee petition itself did not have to meet a clear and convincing evidence standard. It only requires that the lower preponderance of the evidence standard to support a fee petition claim. While the guardian ad litem expressed confusion over this matter, it's unclear why. The trial court was stating that the fee petition required a preponderance of evidence standard of proof, but in deciding to reduce fees based on objections made, the court found the evidence for those objections to be clear and convincing, thus being greater in evidentiary strength than what was used to support the fee petition submitted. The statement of decision couldn't be more clear about this, and it is curious that the guardian ad litem appealed the trial court's decision without fully understanding it. For how could it know an error took place if it didn't understand what the court did? No meaningful legal analysis is possible by a party that doesn't understand why it was done. The trial court specifically stated it did not rely on those arguments. The court is not accepting as true anything stated in those closing arguments by any party or attorney unless such statements are supported by admissible evidence. I'm not sure how the trial court could be any more clear than it expressed. It expressly did not use closing statements or arguments as evidence, and they had to be supported by admissible which indicates that they themselves were not evidence. The guardian ad litem argues A and F. Neither should be found persuasive, as the guardian ad litem is attempting to conflate judicial immunity from lawsuits and affirmation defense, citing McClintock as an authority to protect a fee petition from opposition, something McClintock has nothing to do with, as the case deals with judicially appointing officers immunity from lawsuits. Trying to use McClintock as an authority to protect a fee petition from scrutiny or challenge isn't comparing apples to oranges. At least they're both fruit. It's comparing apples to venison steak and has no supporting authority for a novel legal position, conflating an affirmative defense from a lawsuit like immunity to use as a means of protecting an entitlement request from scrutiny. If appellant Mr. Shaver were correct in his claim, it would result in any guardian ad litem, once appointed, being able to charge any fees they wanted with no one able to stop them. A ludicrous outcome that flies in the face of reason and logic. I wish to make a special note here. Opposition to the fees being requested is not retaliatory, as claimed by appellant Shaver. It is just a minimal measure to ensure that the fees being charged are reasonable, since they're an entitlement being lodged against an estate. Without the ability to challenge or test fee petitions, there would be no stopping someone from bilking any estate once appointed by a court of law. This is assuredly not what either the judiciary wants nor what the legislator ever intended. The last point I wish to make here is that the argument E by the guardian ad litem is instructive. 3 paragraphs are spent on justifying why taking no action regarding allegations of missing guns was unacceptable. The last line states, the gun issue had nothing to do with any reduction in his fees petitioned for by the trial court, making the entire argument section de facto frivolous. It's frivolous. To so blatantly waste everyone's time, including this honorable court, should carry with it a special consideration for sanctions so that these attorneys do not do this ever again, and other attorneys are reminded to not do something like this. This honorable court has given the authority to do so under California Rule of Court 8.276 A 1 through 4 and per Kim v. Westmore Partners Inc. 201 Calif 4th 267. The respondent asks this honorable court not to distribute the well-reasoned, almost impeccable statement of decision, and only ask in addition that all court costs and preparation for this appeal associated with both the appeals be awarded to respondent, and should the court consider the admission by the guardian ad litem for the novel attempt to conflate immunity to a fee petition for an entitlement instead of protection from liability, and the outright admission that argument E lacked any purpose whatsoever, and finally, that neither appellant could cite a specific claim or argument that was used as evidence as reasons for sanctions for submitting appeal issues. Okay, I'm going to calm down. Sorry, guys. and take the appropriate steps to see that offending parties are sanctioned so they don't do this again. Thank you to this honorable court. I know your decision is in God's hands at this point. I appreciate your time and the accommodations.
Any final words, Mr. Shaver?
Thank you. Just briefly, I heard punishment and stuff, and that's, I'm not here to be punished. And there is a distinction between the court's discretion in deciding whether a particular attorney fee entry was reasonable, the time spent or the hourly rate, as opposed to the decision-making that went by, and that's the distinction I'm trying to make. Okay, I wasn't gonna bring it up, but there was an issue about the guns, and one thing I remember about this trial on this was I got interrupted and asked about whether or not I responded to an email on a gun. And
Whether or not what?
I had responded to an email about a gun, about some missing guns. And
Is this in the record?
it is. So, didn't spend any time on the guns. When I went back and looked at it, and I provided additional work on it, it was something that I, as the GIL, would not have been involved in. To this day, I would not have spent any time or charged the estate's time in dealing with that particular issue. So, with that, I'll submit. Thank you.
All right. Thank you, Mr. Shaver, and once again, thank you, Ms. Sussman. The matter is submitted. Court is in recess until 9:30 tomorrow morning. With regard to the students in the law